Broken threads of Justice EEO complaint appeal brief filed today. Dear Agency Attorney. Introduction. Appellant appeals the decision of Honorable Administrative Judge regarding her claim for constructive discharge, retaliation, harassment, hostile work environment, differential treatment between JV, Manager Senior Advisor AS, appellant and others, and discrimination of appellant on the basis of race, white Middle Eastern, national origin Iranian American, disability and reprisal, for whistleblowing in prior EEO activity November 2019 EEO case, as well as the decision to disallow key witnesses to be heard or fair hearing to be provided for this case. Here we appeal and request a hearing and the opportunity for key witnesses to be heard. The lower court erred in ruling that the actions of the agency did not meet the legal standard for discriminatory retaliation or create working conditions that were so intolerable that a reasonable employee would be forced to resign. This appeal asserts that the record, when properly evaluated under applicable law, demonstrates that agency's actions were discriminatory, retaliatory, and led to a constructive discharge in violation of federal and state employment laws. Evidence provided throughout the record shows that retaliation was the likely cause of the adverse action against the employee, such as separation from work, demotion, as well as other adverse actions. Smash the like button for the YouTube algorithm. Slow this video speed if you wish to take notes as you follow along. Statement of facts. Appellant was hired by agency on or around September 15, 2019. Protected activity. Employee engaged in a protected activity of filing an EEO complaint on or around November 8, 2019 for events October 1, 2019 to around January 2021. Appellant was promoted to GS-12/IC-12 on or around April 9, 2021 to serve agency in Saipan, Northern Mariana Islands for Region 9 agency based out of Oakland, California. On this hiring date, appellant was hired by agency for the position of Environmental Protection Specialist, Senior Advisor, and Manager for the Environmental Department with a clear understanding of the nature and scope of job duties, which included in-office work and direct coordination with other departments, clients, or colleagues, as well as direct communications with high-ranking government officials of Guam, Saipan, Tinian, and Rota for multi-million-dollar projects to, for example, respond to damages to schools, power lines, water lines, vegetation debris impacts, residential housing damages, and other issues that had endangered species and historic preservation sensitivities. These sensitivities required upper-level legal knowledge base of the ESA and NHPA to ensure compliance of the in accordance with biological agreement consultations, memorandum of agreements, programmatic agreements, and the archaeological treatment plan in place in Saipan, which MTJ trained appellant in April to October 2021. JV and Manager Senior Advisor as were never trained on implementing these compliance documents until appellant was required to train them on required compliance actions and perform their compliance reviews for them because they were unqualified and or untrained. Smash the like button for the YouTube algorithm. Important dates for this case filing. Appellant completed mediation for this EEO complaint November 12, 2021 to January 18, 2022, with no action taken to resolve appellant's reported concerns on or around December 15, 2022. Based on email from EEO Counselor Advisor. Appellant completed mediation for this EEO complaint again with separate EEO Counselor Advisor D. February 18, 2022 to April 1, 2022, where she informed parties she would no longer participate because the meetings were intended to harass and impact her job or similar words. Appellant requested all EEO issues be halted by management via emails in December 2021 emails, April 1, 2022, email, April 8 or 9, 2022 meetings, as well as on other dates. Agency never took actions to address appellant's reported concerns or complaints through present. Appellant completed informal complaint process for this case was November 3, 2021 to April 18, 2022. Appellant filed the informal complaint formally on April 18, 2022, via email to the agency EEO counselors, advisors, and online submission procedures. Incidents continued through to eventual July 12, 2022, resignation and retaliation experienced still today based on appellant's findings. Appellant initiated and filed the formal EEO process on April 18, 2022, and agency provided a right to file a formal complaint document and process the complaint formally based on appellant's filing of the EEO complaint formally via email and online submission procedures. Appellant filed a whistleblower complaint online on April 18, 2022, but is unsure how that process works and never heard anything about it. The appellant filed this EEO complaint formally for agency actions November 3, 2021 to July 12, 2022, based on her inability to gain resolution of actions within informal mediation with agency EEO counselors. On or around December 12, 2021 and February 4, 2022, agency replaced appellant with another individual in the same position in which she was hired. Despite appellant's continued efforts to perform her duties, she was informed that she would be restricted to take forced time off November 8 to 12, 2021, and remote work with restrictions effective on or around April 18, 2022, severely limiting her ability to perform essential job functions. These actions directly impacted appellant's productivity, professional opportunities, and ability to engage with key office personnel. After repeatedly raising concerns with management, no action was taken to remedy the situations, further exacerbating the hostile work environment. Smash the like button for the YouTube algorithm. Adverse and hostile employment actions. Employer's actions constituted an adverse employment action, significantly altering the employee's work conditions or employment status. Employer took adverse action when they separated appellant from working from her office in F4 building November 2021, which led to appellant being forced to take sick leave and work unpaid from home, all evidenced by emails confirming meetings completed, etc. On or around November 7, 2021, JV verbally abused appellant publicly, then went absent without leave, AWOL, absent from their assigned duties without proper approval with no disciplinary actions. Instead, appellant was separated from work offices, forced to take sick leave, and work unpaid from her residence in retaliation for prior protected activity because appellant became worried about JV's health and safety when she both went AWOL and did not show up for work the following day after JV's 1 p.m. public disturbance JV caused, where she made verbally abusive, disrespectful statements to appellant in front of the lead JL, logistics chief, contractor DM, and contractor TD. As a result of this disturbance, appellant was demoted while white Caucasian JV was never disciplined, instead promoted from trainee to lead to replace lead JL within his position. Later, JV was again promoted to manager and senior advisor, although against agency policy, as she was a trainee unqualified new employee hired on or around September 15, 2021. See JV deployment orders placed to record. Employer demoted appellant in the senior advisor position in which she was hired November 2022. November 2022, employer changed appellant's duties and responsibilities to the extent appellant voiced confusion on what her job was and how to do her job due to the significant changes made to the position duties in which she was hired to perform. See emails. Employer replaced appellant in the position in which she was hired and manager and senior advisor EM to take on her position on or around December 18, 2021 to February 4, 2022. Employer replaced appellant in the position in which she was hired as they deployed manager senior advisor AS to take on her position February 4, 2022 through the date of resignation. Employer took adverse action against appellant when they disallowed appellant to quarantine for COVID-19 against agency, OSHA, and Saipan CRC policies, although they allowed AS to quarantine the following week for her interactions with appellant, which only occurred due to this failure to quarantine the appellant the previous week that impacted appellant and public health and safety of all staff. Manager Senior Advisor AS forced appellant to take sick leave to ensure her own health and safety and the public health and safety of others on Friday, February 10th, when she denied appellant's request to quarantine at 1300 Thursday, February 9th, 2022. Manager Senior Advisor AS required appellant to work from the offices and not quarantine Monday through Tuesday, 1300 February 14th, 2022. Both disregarding Sunday night email, where appellant voiced concerns to public health and safety, as well as provided agency policy that stated appellant was required to quarantine. 0900 to 1100 February 14th, 2022. The agency contact tracing team required appellant to quarantine immediately, but Manager Senior Advisor AS disallowed this quarantine through 1300 and publicly harassed appellant and yelled at appellant to stop talking as she voiced her health and safety concerns as Ops Chief LC sat in front of Manager Senior Advisor AS's desk observing the disturbance. Manager Senior Advisor AS took actions to force appellant to change sick leave. Manager Senior Advisor AS previously approved to leave without pay, LWOP, or vacation time against agency policy when appellant was sick with COVID-19. Appellant was forced to complete daily work logs, disallowed to list things in her calendar for non-work hours, disallowed a COVID-19 testing kit on or around June 8, 2022, in retaliation, although previously provided an agency testing kits before the April 2021 restrictions were placed on appellant. Agency COVID testing kits are also provided to ensure health and safety, as well as made available by the agency to all agency employees and all Saipan residents for free. Appellant was denied COVID testing kits, although available to everyone on island, both employees and residents, even though appellant was both an employee and a resident. Smash the like button for the YouTube algorithm. Slow this video speed if you wish to take notes as you follow along. Appellant was harassed for taking sick leave when she had COVID-19, where Manager Senior Advisor AS took actions to force appellant to take LWOP or vacation time. Employer completes quarterly performance evaluations in secret and does not make them available for appellant to review or sign, as normally occurs for all employees January 2022 to date of resignation. Employer required appellant on numerous occasions train her replacement and other staff in how to complete appellant's duties and ensure compliance for the 3 programs in accordance with biological agreement consultations, memorandum of agreements, programmatic agreements, and the archaeological treatment plan because appellant was a model employee and vital asset to completing the mission. Employer required appellant on numerous occasions complete project review determinations for others because environmental department staff, including JV and manager senior advisor, as were not qualified or trained to be able to make compliance determinations. Employer required appellant provide feedback to historic and bio staff for the ADP contractor compliance presentation, then harassed appellant when she provided feedback. Employer required appellant provide feedback for deploying 1 biological contractor because appellant successfully deployed 7 contractors August 2021. When appellant provided a solution of deploy a lower-level biologist temporarily until an upper-level one can be identified, agency implemented this plan to deploy a candidate SM that appellant encouraged agency to select based on her qualifications. In contrast, manager senior advisor has failed to resolve this issue in under 6 weeks when she had several weeks notice the previous biologist was leaving and only resolved all by implementing the appellant's solution plan. Employer required appellant partake in lengthy more than 2-hour-long meetings several times weekly with EEO counselor advisor D and manager senior advisor AS that were prolonged, lengthy in duration, numerous, frequent, never addressed issues, verbally abusive with the intent to harass, impacted appellant's job, and repeatedly left appellant in tears February 15, 2022 to April 1, 2022, until appellant emailed EEO counselor advisor D that she was no longer going to partake in the meetings on or around March 31, 2021. Appellant notes for these meetings were documented in emails submitted for the ROI, but like other evidence, agency intentionally had this evidence excluded from evidence. Email notes for the meetings were submitted into evidence to the investigator, but the supposedly neutral investigator purposely deleted this and other evidence within the formulation of the EEO report of investigation, ROI. Agency attorney agreed on or around September 2023 that one may perceive the agency took adverse action against appellant on or around April 18, 2022, or similar words, when they separated appellant from working from her office in F4 building and placed her in a restricted employment status. Employer forced appellant to stop participating in training on or around April 18, 2022, although all staff are required to complete this training. Appellant was forced to leave offices to go home, even though appellant informed Director KL of her interest in completing the training she was participating in before leaving the offices. Appellant, a lower-level manager senior advisor within Saipan deployment, was directly overseen by high-level Executive Region 9 Director of HM, which oversees the Environmental Department Regional Advisor, who oversees the Assistant Regional Advisor, who normally oversees appellant. California and Washington, D.C. high-level executive directors of OER and HM came to Saipan Island in retaliation without adequate justification. Appellant was disallowed to interact with co-workers, email co-workers, attend required training, or attend events outside of work hours, i.e. July 4th events, etc., which evidenced her perspective that she was placed in workplace solitary confinement. The agency purposely deleted and fabricated evidence within the formulation of the EEO ROI report of investigation. September 18, 2024, and the EEOC decision disregards agency's unlawful actions and impacts to appellant. EEOC declines to place sanctions on agency for these unlawful actions to avoid justice, defame, slander, and libel appellant. Agency requests for sanctions against appellant is evidence of retaliation, although a protected activity. The EEOC declines to realize that the agency's request to place sanctions on appellant is in itself evidence of unlawful retaliation that impacts individuals, so they will not file complaints, although a protected activity. Causal connection. As evidenced, a causal link between the protected activity filing of 2019 case exists, especially as February 4, 2022 to July 12, 2022 appellant S managerial position in which she was hired was given to someone from her 2019 EEO case manager senior advisor AS, and the adverse employment actions all occurred based on key witness MJ, who here was never provided opportunity to be heard. Evidenced 2019 case TC and CK involvement preceding the adverse actions chronologically described. To begin, for this case, November 3, 2021, for this case, evidencing retaliation was a motivating factor for actions taken against appellant. Smash the like button for the YouTube algorithm. Pretext for retaliation. Employers' stated reasons for adverse actions were a pretext for retaliation, undermining their credibility. Witness testimony. Employer presents witness testimony supporting the employee's claims of retaliatory behavior and constructive discharge. Separately, key witnesses of the appellant have not been heard. Hostile work environment. Employer's actions contributed to a hostile work environment, leading to constructive discharge. Evidence of discrimination. evidence of discrimination based on race, nationality, disability, and/or retaliation for whistleblowing exist, and the agency has a historic pattern of retaliatory behavior and differential treatment as evidenced by their actions to terminate or force an EEO counselor/advisor to retire on or around February 2020 within 2019 case, as well as other actions and specific statements made by TC in that case, where he specifically stated, "It took 3 years to get rid of the last person who complained," said on or around January 9th, 2020. Agency's pattern of retaliatory behavior, repeated failure to address issues, and use of exorbitant tax dollars to counter EEO complaints, both travel expenses and labor hours for executive and non-executive employees, instead of resolving them at the lowest levels within mediation, are not sufficiently considered within this September 17, 2024 decision. The decision, as it stands, sets an abusive, unlawful precedent that federal agencies are above the law, all-powerful, and do not need to ensure public trust as they pay out travel and labor hours to counter and not address EEO issues at the lowest levels. Agency has demonstrated a pattern of retaliatory behavior by repeatedly failing to address employee concerns and equal employment opportunity (EEO) complaints. Instead of resolving these matters through mediation at the lowest levels within the informal complaint process, the agency has repeatedly chosen to invest significant public resources, including exorbitant travel expenses and labor hours for both executives and non-executives, in efforts to counter complaints. This not only squanders taxpayer money but also undermines the principles of fairness and accountability. Furthermore, appellant was intentionally, wrongfully defamed, although in actuality always a model employee. TC stated January 9, 2020 in 2019 EEO case, with performance evaluations that repeatedly document only excellence March to October 30, 2021, where DRM-RC was no longer doing her evaluations. Instead, Executive Director of HMKL did them November 1, 2021 to July 12, 2022, end of employment. The September 17, 2024 decision fails to adequately consider these critical issues. By allowing the agency to continue this approach, the decision sets a dangerous precedent, implying that federal agencies are above the law and that they need not prioritize public trust. Instead of addressing legitimate employee grievances, the agency's current practices suggest that it is acceptable to use public funds to avoid accountability, which contradicts the fundamental purpose of government agencies and erodes trust in their ability to uphold the law and act in the public's interest. Employer knowledge. The employer had knowledge of the employee's protected activity June 9, 2021, as evidenced within pre-hearing reports, and a retaliatory intent exists. Timing of actions. The timing of the adverse actions in relation to the protected activity support the inference of retaliation. Comparative treatment. Similarly situated employees who did not engage in protected activities were treated more favorably, as evidenced repeatedly throughout appellant's case. Lack of investigation. As evidenced repeatedly, the employer failed to conduct a thorough investigation into the employee's complaints, failed to address concerns, selective gathering of statements, choosing witnesses or evidence that would support the employer's position, deletion of evidence from the formation of the report of investigation, ROI, and only took statements from individuals strategically to further their own claims, indicating both indifference to the allegations and strategic intent to undermine the integrity of the case within a court of law. The employer engaged in unfair or biased practices when handling the employee's complaints. Agency acted with negligence in failing to investigate and intent in manipulating the situation to favor their defense. Indifference and strategic manipulation. The employer's actions show a disregard for the employee's allegations and suggest that the employer deliberately acted in a way that would undermine the employee's case in court, rather than seek the truth or a just resolution. Unlawful exclusion or tampering with evidence when forming the EEO report of investigation, ROI. See pre-hearing reports and motions of appellant provided on or around September 2023. See appellant's requests for counter-sanctions against agency listed within the pre-hearing motions. Retaliatory harassment. Harassment or mistreatment followed the employee's protected activity of filing 2019 EEO case, incidents November 2019 to January 2021, reinforcing claims of retaliation. Remedial action. Employer repeatedly failed to take appropriate remedial action after being made aware of the discriminatory retaliatory conduct. Failure to follow company policy. Employer did not adhere to its own policies regarding, although not all inclusively, employee complaints, disciplinary actions, COVID-19 testing and quarantine, implementation of adverse actions, demotion actions to include, although not all inclusively, the requirement to provide appellant a written notice and ensure demotion is justified based on documented issues that never existed, as appellant only had excellent evaluations documented, leave administration. actions for sick leave, leave without pay, vacation time, and remote work, performance evaluations actions, implementation of job description in which appellant was hired, training requirements oversight, and supervisory oversight by executive officials like the Director of OPR and Director of HM instead of the normal supervisory oversight by the Regional Advisor and Assistant Regional Advisor. Relevant statutes. Statutes relevant to the case include but not limited by Title VII of the Civil Rights Act of 1964, Equal Pay Act of 1963, EPA, Americans with Disabilities Act of 1990, ADA, Family and Medical Leave Act, FMLA, denying eligible leave or retaliating for using leave. Forced sick leave use. Forced use of LWOP and vacation time when sick with COVID-19. Section 1981 of the Civil Rights Act of 1866, Section 1981 of the Civil Rights Act of 1866, prohibits race discrimination and violations for hiring, promoting, demoting, etc. Fair Labor Standards Act, FLSA. Prohibits discrimination or retaliation against employees for asserting their rights. Occupational Safety and Health Act, OSHA. Whistleblower Protections, Families First Coronavirus Response Act. FFCRA for unsafe implementation of COVID-19 quarantine and testing, California Fair Employment and Housing Act, FEHA, and or others. Smash the like button for the YouTube algorithm. Whistleblower Protections. Appellant qualifies for whistleblower protections, further enhancing the claim of retaliation. In addition to case facts clarifying retaliatory actions taken, the agency requests for sanctions against appellant are also retaliatory. Exorbitant documentation for superficial issues and misrepresentation of facts. Prolific pattern of pretextual disciplinary actions. Agency documents performance issues in bad faith as a way to justify adverse employment action as a form of retaliation or discrimination. Employer pattern of over-documenting or exaggerating minor performance issues in order to misrepresent the facts and justify disciplinary actions against an employee to include excessive documentation for superficial issues. The employer is creating an unusually large amount of documentation for minor or trivial issues as a tactic to build a false narrative about the employee's performance. Strategic disregard of multiple performance evaluations evidencing not just average performance, instead excellence within her employment position March 2021 to October 31, 2021, which also includes a promotion. Strategic intent to misstate facts. The employer's actions suggest they are deliberately distorting or manipulating the facts, possibly to create a pretext for disciplinary action or termination. The focus is on shaping the narrative rather than addressing genuine concerns. Misleading facts. Evidence of exaggerated or inaccurate claims about the employee's conduct or performance exist, making the employee appear as though they have significant issues when in reality, the issues are minor and based on the fact appellant previously complained, if any at all. Minute issues labeled as severe, minor or insignificant matters are being presented as major misconduct or severe performance problems, further supporting the narrative the employer is trying to build. Inconsistent treatment of employees. The employer may be ignoring similar or more serious issues from other employees, showing favoritism and bias. This inconsistent enforcement of discipline indicates discriminatory or retaliatory intent, highlighting unequal treatment. Furthermore, evidence-targeted actions against appellant. Use of executive officials to form documentation against appellant. Director OPR, Director HM, and EEO Counselor DE, who served the agency since the agency was established as an agency in 1979 about 45 years ago, were all executive employees utilized to combat appellant S claims. Agency had executive officials, directors of agency, and the best of the best EEO Counselor Advisor work closely to oversee and meet with appellant to combat appellant S claims. Appellant is just a 27 to 30-year-old employee with a highly credible reputation for excellence who goes above and beyond in all aspects of any job. Unlawful delay of justice and failure to address issues. Retaliation can take many forms, including delays and failure to address complaints. See appellant September and October 2023 motions and pre-hearing reports. Agency abusive request of punitive measures, such as fines or sanctions against an employee who filed an EEO complaint in violation of anti-retaliation laws, anti-SLAPP laws, Title VII of the Civil Rights Act of 1964. See Agency September and October 2023 motions and pre-hearing reports. Retaliatory actions may include delays in resolving complaints, threats of fines, or other forms of punitive measures that discourage individuals from exercising their rights under anti-discrimination statutes, punish the appellant, or delay justice. Anti-SLAPP laws. California and Pennsylvania have anti-SLAPP laws, strategic lawsuit against public participation, under California Code of Civil Procedure Section 425.16 and or 42 PA C.S. Section 8303, which are designed to protect against defamation, acts to silence free speech or public participation, retaliatory actions, and actions that intimidate or punish individuals for exercising their rights, including filing complaints or engaging in protected activity. If an agency's actions are interpreted as retaliatory or meant to suppress complaints, like threats of fines, they could be in violation of state or federal anti-SLAPP statutes, especially if the actions infringe on First Amendment rights or are seen as retaliatory, coercive, or intentional. On a federal level, courts have recognized the use of SLAPP, strategic lawsuits against public participation, tactics, and have dismissed cases that seek to unfairly punish individuals for exercising protected rights, including filing legal complaints like EEO grievances. Actions that deter or delay justice could be seen as violating public policy principles of fairness and justice. Retaliation can occur when employers delay resolution, fail to address issues, or take actions that could deter someone from pursuing their complaint. Relevant case law. Tomeni versus Atlantic Richfield Company, 27 calories, 3D 167, 1980 California Supreme Court case allows employees to bring a tort action if they were discharged in retaliation for refusing to commit an illegal act or for asserting their rights. While not specifically an anti-SLAPP case, this case forms a basis for employees' rights to speak out, which can be protected under anti-SLAPP if employers retaliate against EEO or other complaints. Horan versus Hickson, 209 calories, App. 4th 256, 2012, the court addressed an employer's attempt to use anti-SLAPP protections in the context of an EEO dispute. The court denied the employer's motion to strike an employee's defamation and retaliation claims, affirming that the employee's efforts to file a complaint were protected activity. Appellant requests sanctions against agency for abusive retaliatory actions that deter individuals from pursuing protected activities and taking unlawful actions to exclude evidence from the ROI, manipulate evidence, delay justice, and other actions. See Appellant's September and October 2023 motions and pre-hearing reports. Appellant again requests sanctions against agency, requests summary judgment decision in appellant's favor, a fair hearing for key witnesses and appellants to be heard, and or other resolution or relief available based on the facts of the case. Public policy considerations. The decision as it stands does not speak to broader social, economic, and ethical reasons for ensuring that discrimination and retaliation are not tolerated in employment practices. Instead, it justifies exorbitant amounts of spending of public tax dollars to combat claims instead of addressing them at the lowest levels outside of formal legal processes. Appellant despises filing complaints because she finds them to be a waste of life, repeated reliving of trauma, only to be defamed and taken advantage of within the process. Appellant had no other option than file this formal EEO complaint because of agency actions to force her to take sick leave, failure to discipline JV, unjustified evaluation November 3rd, 2021, which contradicted excellent performance evaluation just several days prior, relocation of work desk, demotion, reduction in duties, separation from work offices November 8th to 12th, replacement within her position, and failure to address concerns at the lowest level within mediation meetings NOV to December 2021 with this EEO counselor advisor at that time. This EEO counselor advisor was replaced by EEO counselor advisor D, who fostered intentional harassment of appellant within meetings, fabricate reasons to terminate appellant, and take appellant away from doing her job. EEO counselor D intentionally scheduled frequent, lengthy meetings, 2+ hours long, several times weekly February 18th to April 1st, 2022 with appellant and manager senior advisor AS to harass appellant, manipulatively fabricate and document reasons to terminate appellant, and take appellant away from doing her job until on or around March 31st, 2022, when appellant informed all parties in an email she would no longer be participating in mediation meetings with manager senior advisor AS and EEO counselor because the repeated use of the meetings to harass and impact appellant within her job. Just a few weeks after ending these meetings, the appellant was removed from work on April 18th, 2022. D stated on or around March 28th appellant should be careful and stay low, but at least she was good at her job, or similar words, because he knew what the agency was doing and took part in these actions against appellant. Constructive discharge standard. Working conditions were so intolerable that a reasonable person would feel compelled to resign. Appellant specifically stated within multiple emails to EEO counselor advisor D and agency management to request conditions to improve because they were so intolerable, and clarified that she wanted to resign based on these conditions in April before she was forced to separate from work and enter a restricted status on or around April 18th, 2022. See emails on or around April 1st, 5th, or 9th. By April 2024, the working conditions had deteriorated to such an extent that appellant felt compelled to resign due to the adverse impacts on her job performance, the lack of response from the agency, and the significant shift in her working conditions, and this was all documented in black and white within emails to management officials. These conditions only continued to deteriorate further April 18th to July 12th, 2022 due to ongoing severe adverse actions against her. One should review all appellant placed to record to form a just decision for this appeal. Slow this video speed if you wish to take notes as you follow along. Appellant background story. Appellant historically only achieves excellence in all her employment positions and all her academic degrees. She started in high school, graduating with honors with a top GPA, president of multiple clubs, participating in 12 clubs and 3 varsity sports each school year, captain of swim and volleyball team with 5 medals, Jessica Webb Award, and records based on season and all-time statistics. Appellant here began U.S. Coast Guard service, working 24/7, serving at the U.S. Coast Guard Academy and Marion Military Institute, highly selective programs who teach you when you make mistakes people die. Hence her high level of performance, mitigating mistakes always. Appellant received the National Defense Service Medal for U.S. Coast Guard military service during Operation Iraqi Freedom Time of War, July 2009 to May 2012. This led to Appellant's continued focus on perfection and excellence in all she does. Here she excelled and was given more responsibility and duties than normal people. Appellant transferred to the prestigious SUNY Maritime Academy, which is known for high-caliber academics and professional alumni, where she was hand-selected to tutor a disabled student by the academic dean and graduated with top GPA of 3.789 with honors in volleyball, where she was also team captain and record holder, honors in cross-country, and on the Admiral's list. Like 6 U.S. presidents, Appellant was a member of the Omicron Delta Kappa Leadership Society, where again the dean informed her she should run for being president, although not chosen in time for graduation. Here, before graduation, she served at NASA Stennis Space Center and NMFS. After graduation, she began serving NOAA Department of Commerce for 4 years in arguably the most challenging employment position in the world aboard NOAA ship Oscar Dyson, also coined the label Oscar Die Soon, because this academically challenging position required serving in the stormiest place, the Bering Sea, Alaska, where salty fishermen would quit after a week, leading her to serve as a fisherman for a month on top of her normal duties as a technician, here always serving 12 hours 7 days per week for over 10 months straight without a single day off, insane daylight hours, freezing temperatures, and work schedules. For her time serving a highly challenging employment position with NOAA, was a resilient, hardworking employee, as 3 or 4 NOAA employees committed suicide, where 2 she knew personally. If angels saw all agency put Appellant through, they would see all would lead a normal employee to resign in their position by April, as Appellant eventually did so with agency. The Appellant decided to pursue something seemingly impossible, a master's degree in environmental law and policy from Vermont Law School. Here she graduated top of her class with 3.635 cumulative GPA, where students would exclaim, "How do you do so well in class? It is so difficult." Appellant wanted an easier job that doesn't leave her freezing and pursuing countless certifications, because the government always overcertifies you so you can perform insane amount of duties all in one workday. Instead, shifted to NOAA ship Arth Brown, working again 12-hour days 7 days per week from Alaska to Antarctica to Africa coastline to South Carolina. Here she gained multiple awards and unit citations for her work, including the unit citation for 1,347-day-long deployment in support of rigorous scientific missions with ribbon, medal, and plaque. National Science Foundation Antarctica Service Medal of the United States of America for exploration and scientific achievement, Ancient Order of Red Nose Certificate, Ancient Order of Shellback Certificate, Ancient Order of Golden Dragon Certificate. Before leaving service for this ship, the temporary assistant director of NOAA met Appellant and stated she was a great employee who he hopes serves NOAA for the next several decades due to her excellence, within a conversation in the cafeteria with Appellant's family and herself. Appellant was one of 14 members of the OMAO Diversity and Inclusion Council hand selected by Rear Admiral SCORE, where she helped form their core values and original mission statement. OMAO is the bigger body that oversees NOAA operations. From here, Appellant achieved the highest rank of senior survey technician aboard NOAA shipset, where she served 12 hours days once again, instead often working extra, as here, unlike other ships, she was the only technician on board within the survey department she managed. NOAA certifies you in everything so you can do your job and extras for the same pay rate. Appellant served as an Assistant Environmental Compliance Officer, AECO, Advanced Open Ocean Professional Scuba Diver, Rescue Swimmer, Fast Rescue Boat Coxswain, as well as other collateral duties on top of her senior technician duties. Appellant next served ACWD within the 3rd highest position from the top within the agency for her position as a Water Quality Engineer 2, replacing the permanent engineer during her maternity leave. Appellant hit the ground running, proficient in weeks in a position that takes years to become competent, according to her supervisor. Appellant ensured 3 cities in San Francisco area had clean drinking water and compliance with their programs. Of course, her success was due to great training received by a fellow engineer who is the best at all she does. Before leaving, Appellant improved their data management systems, which required manual data entry, but after much troubleshooting, the permanent engineer returns to have water quality data auto-populating from daily data accrual in the field. This improvement made operations forever more efficient and accurate, as human error is mitigated. The engineer now does minimal data entries, instead confirms accuracy of auto-generated data. As an EPA Emergency Preparedness Manager contractor, appellant ensured emergency equipment was ready for EPA emergency responders. Emergencies are often Superfund toxic, fire, mold, asbestos, or other hazard-related issues. Appellant Epic failed at solar project management sales. She fails in sales and sold nothing, instead learned 4-plus-inch binder of content about everything and anything and spent countless hours encouraging renewable energy projects for commercial and residential properties. Go green. Appellant probably knew more than everyone, but quickly learning the information does not mean you can communicate to get someone to invest in renewable energy when they have other priorities and other quotes. Appellant perceives her technical background and inability to flatter, instead straight to the facts and detailed data personality did not help her get candidates to go solar. Next for FEMA, appellant completed compliance reviews for all programs as most employees solitarily only serve in IA, PA, or HMGP programs. Appellant regularly completed reviews for all relevant laws including NHPA, ESA, NEPA, CWA, CAA, RCRA, CBRA, CZMA, others, as well as for EO 11988 floodplain, EO 11990 wetlands, EO 12898 environmental justice. Within appellant's time serving FEMA, appellant went above and beyond, served on call 24/7, trained staff, supervised staff, drafted SOPs and guidances, completed over 155-plus certifications, and was promoted to IC-12 position within just under 18 months of 2 years, 10 months of service. Appellant does the impossible in all aspects of everything appellant does. Serving FEMA, appellant always asked for more projects. Appellant simply does more in higher quality in less time than others. Appellant avoids mistakes, instead perfects all appellant does. Appellant always works more than the 8-hour normal workday in all her jobs. While serving agency, appellant separately in her downtime was a coach for children in swimming and volleyball. Appellant was a coach for the Saipan Team 2022 World Championships in Budapest, Hungary, where they came home breaking all-time Saipan records. Appellant saved 15-plus foster kittens, completed night coral reef rehabilitation scuba dives, and countless cleanups. FEMA co-workers gained recognition from management for a few cleanups. Appellant does more and never gains recognition. For this case, appellant does more and never gains recognition, instead gains alleged fabricated conduct issues and fails to gain justice here. Appellant only wants justice and to deter severe unlawful actions by agency against other employees. Maybe social justice is the only viable means to justice based on this present erroneous EEOC process decision favoring all-powerful agency arbitrarily when evidence more likely than not favors the appellant. Agency actions were unlawful, and they will continue to fire EEO counselor advisors and set the all-time most experienced EEO counselor advisor and top executives to harass employees within numerous frequent meetings to fabricate evidence against them with proven pretext. As evidenced, the mere fact executives oversee her, although not normal, is only retaliatory. The EEO counselor was hired when agency was established on or around April 1, 1979, and served over 43 years and 3 months within my time there. This is what the appellant went up against. Agency had the most experienced individuals, i.e. this EEO advisor, Manager Senior Advisor AS from Appellant S. 2019 case, Director of OPR, and Director of Region 9HM to fabricate pretext and harass appellant until the work conditions were so bad she quit a job her credentials are perfect for. Only appellant has a master's in environmental law, graduating top in her class from Vermont Law School to do compliance reviews for agency. Environmental staff often do not even have a master's degree, let alone one specifically from a law school in environmental law. Post-agency, appellant became the top candidate on her supervisor's roster to deploy for this same agency. It is not normal the fact she was not deployed March 2023 to present, even though all these disasters exist throughout the nation. Today, Hurricane Helen and Milton are absolutely destroying Florida and North Carolina properties in her deployment zone. Appellant only sits on the sidelines, likely because agency continues retaliation through the present to impact her ability to deploy for disasters, although overqualified with a history of excellence, all directly evidenced by evaluations and promotions that were disregarded within this decision. The only thing appellant ever did wrong was the filing EEO complaints against the all-powerful agency. Appellant states, "I vow, with full conviction, my only mistake serving agency was filing EEO cases against the all-powerful agency. I swear with absolute certainty, my only mistake serving agency was filing EEO cases against the all-powerful agency. I never had anyone create such absurdities against my character, performance, or reputation so successfully. I am impressed. Then again, it is also insane how agencies spent so many tax dollars to combat my 2019 EEO complaint and retaliate within this complaint where they on several occasions spent. Flight cost for one flight $1,800 to $2,200 from OAK to SBN and $2,000 to $3,400 DCA to SBN. Per diem $140 for lodging and $59 for meals and incidentals per day. Rental cars $75 per day. 22 to 45 hours to fly OAK or DCA to SPN. Thus the agency paid the directors and the advisors they flew with for all travel hours to get all the way to Saipan. According to Google, the average executive officer base salary at an agency is over $139,000 per year, while at IC-12, I only earned $77,000. For a 27 to 30-year-old at the time, it is honestly very much a compliment agency would deploy such high-stature employees, directors, and individuals hired when the agency was established, and waste so many tax dollars just to combat this EEO complaint and defame me as having conduct issues. It is an embarrassment that the EEOC with this decision sets the precedent agencies should deploy such large amounts of taxpayer dollars to combat EEO issues instead of addressing the complaints at the lowest levels within the informal EEO stages, so they do not turn into formal complaints in the first place. Never was any of my 2019 EEO complaint, or this complaint addressed by the agency. OAK Director Hazard Mitigation Travel. For an executive employee GS-15, hourly pay rate $54. Agencies spent. Calculating the lowest posable cost for the travel $1,800 plus 3 days lodging $140 per diem nightly, plus 3 days food, $59 meals incidentals per diem, plus 3 days, rental car daily rate $75, plus 54 hourly pay rate, 22-hour flight travel time, equals $3,810 each time official travels to SPN minimum. Calculating the higher potential cost for the travel $2,200 plus 3 days lodging $140 per diem nightly, plus 3 days food, $59 meals incidentals per diem, plus 3 days, rental car daily rate $75, plus 54 hourly pay rate, 45-hour flight travel time, equals $5,452 each time official travels to SPN minimum. DCA Director OPR Travel. For an executive employee GS-15, hourly pay rate $54. Agencies spent. Calculating the lowest posable cost for the travel $2,000 plus 3 days lodging $140 per diem nightly, plus 3 days food, $59 meals incidentals per diem, plus 3 days, rental car daily rate $75, plus 54 hourly pay rate, 22-hour flight travel time, equals $4,010 each time official travels to SPN. Calculating the higher potential cost for the travel $3,400 plus 3 days lodging $140 per diem nightly, plus 3 days food, $59 meals incidentals per diem, plus 3 days, rental car daily rate $75, plus 54 hourly pay rate, 45-hour flight travel time, equals $6,652 each time official travels to SPN minimum. Note: normally an overnight stay in Hawaii or Guam are required to get to or from SPN, thus an extra travel day of labor hours with lodging with incidental meals not accounted for above, meaning actual travel is probably more costly to the agency. Travel is lengthy, but labor hours will also be spent at the final destination, which means per diem lodging, rental, food, and incidentals may be more than 3 days. Normally, stays are more than 3 days, although we calculated for only 3 days in our calculations. Thus, a low estimate. Even when not traveling, these executive staff oversee appellant within their normal duties regardless of their high-caliber duties. Multiple executive officials, not just one, spends labor hours and travel time to combat EEO complaint instead of addressing informal complaint at the lowest levels with non-executive staff instead of having normal supervisors and staff work with or oversee appellant. Similarly, within the 2019 case, a long-standing EEO counselor was forced to stop working with agency although she quoted she loved her job, would never leave it, and voiced fear of agency retaliation because she rightfully processed the complaint instead of documenting it a late submission, when agency redirected the mail to be late, forcing appellant to separately overnight it for an on-time receipt. Her job ended just weeks later, and she was forced to retire. Executives, her superiors, oversaw that 2019 EEO complaint once this individual no longer served the agency. Note: every year staff serves agency, they gain step increase, pay rate increase, until step 4. In retaliation, appellant never received her earned Step 1 pay increase because she filed complaints. Today, HM Directory KL served agency 14.5 years total with 4+ years within her present branch chief position. See LinkedIn. As a GS-15 HM Director, KL likely earned $178,280 because California locality pay and likely step rate increases for 2022, Step 2 after 1 year, and Step 3 after 2 years. As evidenced, my above calculations were for $139,000 annually. Earnings are very low because actual pay rate for California and Washington, D.C. with high step promotion pay increases is likely much more, so each travel cost calculation should be much higher for a higher than $178,000 pay rate and more than a 3-day stay in Saipan, Tinian, Guam, and Rhode Islands. These calculations evidence Here, agency officials spend exorbitant amounts of tax dollars to combat appellant's EEO complaint and retaliate against appellant, where here EEOC judge sets the precedent: all actions to defame, slander, libel, harass, discriminate, and retaliate against appellant was successful, as judge presently finds no issue with any of agency's unlawful actions against appellant. Appellant lost wages from her forced resignation July 12, 2022 to March 2025 and succumbed to severe hardships, not just due to the adverse actions, but also due to the loss of wages. $77,488 base pay is an estimated $38 hourly, $304 daily. 174 weekdays, Monday through Friday, between July 12, 2022 and March 12, 2023. $304 daily for 174 weekdays equals $52,896 in lost wages. Appellant was hired to serve this same agency, but as a contractor serving a different location, the best candidate on the roster for 3 separate companies, but was never deployed, likely due to EEO case, which led to further financial suffering and undue hardship losses, where 414 weekdays, Monday through Friday, between March 12, 2023 and today, October 10, 2024. Lost wages $304, 414 weekdays, equals $128,856. Total loss in wages $178,752 through present, even though there have been countless disasters and tremendous potential to deploy, i.e. Hurricane Milton, Helen, and many other nationwide disasters. This also does not consider normal annual pay increases, earned step increases, or her present-day pay rate, which is much, much higher than this $77,000 pay rate used for these calculations. To see the scope of the disparity, understand there are 4 prime agency contractors. Appellant was a badged agency contractor March 2023 to present, and as of October 4, 2024, can deploy within all regions except 1 or 2 because she has contacts in all these regions. This is almost nationwide capacity to deploy. It is likely impossible for an appellant with such a rare resume perfect for agency service to be undeployable through present, unless of course continued retaliation is still prevalent today. Appellant lives in Florida, now hammered by Hurricane Helen and Milton. Still no deployment orders for these or past disasters. In retaliation, appellant never received step pay increase April 12, 2022, although requested and normally earned after 52-week service in that position. This is a loss of $2,898 pay increase, not considering COLA locality pay increases. Standard of review. Appellate courts review questions of law de novo and findings of fact for clear error. Appellate courts are to look at legal questions, e.g., the interpretation of statutes or the application of legal principles, freshly, and without deferring to the trial court's conclusions. They assess the law independently, as if deciding it for the first time. Appellate courts review findings of fact for clear error. Pennsylvania State Police v. Sutters, 542 U.S. 129, 2004, provides the standard for constructive discharge claims, requiring an inquiry into whether a reasonable person in the plaintiff's position would have felt compelled to resign due to intolerable working conditions. Additionally, retaliation claims are evaluated under the preponderance of the evidence standard as established in Texas Department of Community Affairs v. Burdine, 450 U.S. 248, 1981. Under the standard, it is proven that it is more likely than not that retaliation occurred. To further clarify, constructive discharge claims require proof that a reasonable person would have felt forced to resign due to intolerable conditions, while retaliation claims must meet the preponderance of the evidence standard, showing it was more likely than not that retaliation occurred. Here, appellant's position was changed in such a way that she could no longer perform her duties, and this led to a forced resignation. Employer intentionally or negligently caused these conditions. Conditions were deliberately created, or that the employer knew or should have known about the conditions and failed to remedy them. The court presently finds it is greater than 50% chance that the agency's version of the facts is true. This is only possible if you disregard direct evidence placed to record. Appellant was always an exemplary employee who literally performed the duties of others and trained others to do her own job, as she was replaced within the position of which she was hired. All began with an incident where JV received no disciplinary action for verbal abuse against appellant, leaving work without approval, and not showing up for work in the office the following day. Repeated adverse actions by agency were evidenced. Relevant case law. Desert Palace Incorporated v. Costa, 539 U.S. 90, 2003. U.S. Supreme Court ruled that plaintiffs in employment discrimination cases do not need to provide direct evidence of discrimination. Circumstantial evidence alone is sufficient to meet the burden of proof if it shows that discrimination more likely than not occurred. Circumstantial evidence, such as patterns of behavior, comments, or statistical data, can be enough to prove discrimination or retaliation. Here in appellant's case, direct evidence exists as multiple adverse actions are causally linked to appellant's filing 2019 EEO complaint. 5 or more performance evaluations March 2021 to October 30th, 2021, performed by on-site supervisors that directly oversee appellant's work repeatedly evidence not just that appellant is competent and average, instead excelling as she performed her duties with above average to near perfect scores. Just 3 days later, negative subjective evaluation was created with just a one-sentence statement and no justification. See November 3rd, 2021, evaluation by Executive Director HM. Future evaluations through July 12th, 2022, were completed by Executive Director KL in California, but placed to record without appellant's review and/or signature as normally done for all employees. Discriminatory animus is not required for retaliation. It is not necessary to prove discriminatory animus when a claim is based on retaliation. Instead, it is simply important that adverse action was taken because of the protected activity of filing 2019 EEO complaint. Here, retaliation based on the adverse actions taken against appellant occurred based on protected activity of whistleblowing just weeks prior exist, making discriminatory intent behind the initial adverse action not necessary to be proven. Retaliation claims. In retaliation cases, the plaintiff typically needs to prove 3 elements. They engaged in a protected activity, such as complaining about discrimination, filing a discrimination charge, or participating in an investigation. Yes, appellant filed 2019 EEO complaint for incidents October 1st, 2019 to January 2021, which include key individuals CK, TC, and manager senior advisor AS, who within this EEO case became appellant's direct supervisor February 4th, 2022 to July 12th, 2022, resignation. Yes, appellant filed an informal complaint and mediation for this case NOV to December 2021, which received no resolution on or around December 15th, 2021. See email to appellant from EEO counselor stating agency is taking no action to resolve reported issues or similar words. When unlawful activities continued, appellant filed a formal complaint for the November 3rd to July 12th, 2022, resignation. On April 18th for incidents, which is this case we speak of today. They suffered an adverse action, such as being fired, demoted, harassed, or subject to other negative consequences. Yes, see case facts and motions placed to record September to October 2023, where agency states agreement the April 2022 separation may be perceived as an adverse action against appellant. In addition to this adverse action, cumulative effects of multiple adverse actions exist. There is a causal connection between the protected activity and the adverse action, e.g., timing, evidence of motive, or retaliatory statements. Yes, see timelines, evidentiary motives, retaliatory statements, and persons relevant, i.e. manager senior advisor AS from 2019 EEO case becomes appellant's direct supervisor and replaces appellant in the position she was hired. Specifically, February 4th, 2022, manager senior advisor AS from 2019 to February 2022 EEO case was deployed to be appellant's direct supervisor to replace appellant within the position in which she was hired on or around April 12th, 2024. Manager MJ reported to regional advisor, DRMRC, and appellant that agency had motive to hire CK as appellant's direct supervisor June 9, 2021, where they specifically provided her a job offer. Manager MJ reported TC seeking her out to talk to her about appellant or defame her September to October 2021, even though he was never serving Saipan and located in California, while MJ was on the other side of the earth in Saipan, where he was not relevant to ever have the need to discuss appellant to manager MJ if it was not for appellant's 2019 EEO complaint existing. Relevant case law. University of Texas Southwestern Med Center v. Nasser, 570 U.S. 338, 2013. The U.S. Supreme Court ruled that in retaliation claims under Title VII, a plaintiff must show but for causation, meaning the retaliation would not have occurred but for the protected activity. Discriminatory animus is not required to prove retaliation, only that the adverse action was motivated by the employee's protected activity. Retaliation claims require focus on causation, connection between the protected activity and adverse action, rather than proving bias or animus based on race, gender, etc. Kakmer v. SunGard Datasys, Inc. 109 F.3D 173, 3D CIR 1997. Third Circuit case. The court highlighted that retaliation claims require a showing of a causal link between the employee's protected activity and the employer's adverse action, without requiring the plaintiff to prove discriminatory animus. Emphasizing that the focus is on whether the adverse action was a response to the protected activity, not whether the action was motivated by bias or discrimination. Johnson v. Palma, 931 F.2 D 203, 2D CJR 1991. Second Circuit found that an employee can prevail on a retaliation claim even if they fail to prove the underlying discrimination claim. The retaliation itself is unlawful if it is based on the employee's complaint or participation in a discrimination investigation, even without proof of discriminatory animus. The ruling reinforces that retaliation claims stand independently of discrimination claims and do not require proof of bias. Hostile work environment relevant case law. Here, if the change in employment conditions, for example being removed from your office duties, etc., is not tied to harassment based on a protected characteristic like race or gender, it might not meet the threshold for a hostile work environment claim unless the actions are severe and pervasive to impact the conditions of employment. However, if the employer's conduct was severe enough to force you to resign, you might have a constructive discharge case. Burlington Industries Incorporated v. Ellerth, 524 U.S. 742, 1998, and Farger v. City of Boca Raton, 524 U.S. 775, 1998 cases establish that for a hostile work environment claim, conduct must be sufficiently severe or pervasive to alter the conditions of employment. The standard is both objective and subjective, where the behavior must be severe enough that a reasonable person would find the work environment hostile or abusive, and the employee must also have found it hostile or abusive. In Farger v. City of Boca Raton, 524 U.S. 775, 1998, conditions that limit an employee's ability to perform essential job functions or interact with necessary office resources can create a hostile environment. McCoy v. City of Shreveport, 492 F.3d 551, 5th Circle, 2007. The court analyzed whether a performance evaluation was retaliatory. The Fifth Circuit ruled that a negative evaluation issued after the employee engaged in protected activity, like reporting harassment, was an adverse action because it affected the employee's promotional opportunities and created a hostile work environment. Harrison v. City of New York, 2018 U.S. DIST Lexus 112783, EDNY 2018, court ruling emphasized that forcing an employee to deplete their leave affects their autonomy and work-life balance, contributing to a hostile work environment. Discrimination relevant case law. Pennsylvania Human Relations Commission v. Alto Rest Park Cemetery Association, 453 Pascals, 124, 1973, the Pennsylvania Supreme Court outlined that for employment discrimination claims, the employer's actions must have a sufficiently adverse impact on the employee's conditions of employment. If the change is subtle or minor, it may not be considered severe enough. Changes in duties or work location alone might not be enough unless they significantly impact your ability to work or create intolerable conditions. Cleveland v. Policy Management Systems Corporation, 526 U.S. 795, 1999, Supreme Court addressed the implications of denying an employee's claim for benefits after forcing them to take a leave of absence. The ruling highlighted that any action affecting an employee's ability to manage their leave and benefits can contribute to discrimination claims. Robinson v. Health and Hospital Corporation of Marion County, 2022 U.S. DIST Lexus 187522, SDIND 2022, the court ruled that a healthcare worker's inability to take leave due to COVID-19 exposure, which was necessary for their own health and safety, constituted an adverse employment action. This case underscores that denying an employee the ability to quarantine, especially when such leave is warranted under federal law, e.g., FFCRA, can result in harm to the employee's health and may be viewed as retaliation or discrimination. Pivorato v. Innovative Systems Incorporated, 191 F.3d 344, 3D CHR 1999, Third Circuit found that an employer's failure to follow its own policies for promotion and replacement can be evidence of discrimination. An employee replaced by someone else in violation of company policies can use this to show pretext in a discrimination case. If the replacement process violates company policies or standard procedures, it may strengthen the employee's claim of discrimination. Diaz v. Kraft Foods Global Incorporated, 653 F.3d 582, 7th Circle, 2011, court held that replacing an employee with a less qualified individual of a different gender or race can support a claim of discrimination. The plaintiff was able to show that their replacement was less qualified, strengthening their case that discrimination was at play. An employee replaced by someone less qualified or who is a member of a different protected class may use this as evidence of discriminatory motive. JV was never disciplined, promoted to lead, and promoted to manager senior advisor against agency policy, although not qualified and deployed as a new hire trainee just months prior. Argument. See entire brief for arguments. Sorry, appellant is not a licensed attorney and did her best drafting appeal brief. The lower court erred in failing to find constructive discharge. Under Pennsylvania State Police v. Sutters, 542 U.S. 129, 2004, a constructive discharge occurs when working conditions are so intolerable that a reasonable person would feel compelled to resign. The facts here demonstrate that appellant's ability to perform her duties was substantially diminished by separation from work, November, forced use of accrued leave, November, demotion, November, replaced within the position she was hired, December, February, June, coerced to use LWOP and or vacation time when sick, February, negative evaluations, November, etc. inability to quarantine for COVID-19, February, and the shift to remote work with restrictions, April, which amounted to a material alteration of her employment conditions. Like Sutters, appellant here faced a significant change in job duties and conditions that all began November 2021. Moving from in-office responsibilities to remote work in April 2022 further negatively impacted her productivity and ability to perform the role. The loss of access to the office and direct support staff made continued employment untenable. The record shows that appellant repeatedly communicated the negative effects of this change to management, but no remedial action was taken. Appellant voiced in emails that her position was changed to the point where she could no longer perform her duties and notified DRMRC within November emails. She did not even know what duties her employer wanted her to do due to the changes. DRMRC completed a meeting on November 12th to clarify changes in appellant's duties. By May 2022, appellant did not have projects or interactions with her coworkers. Instead spent each day researching and doing certifications in solitude from home with repeated pervasive restrictions that resulted in a forced resignation. In Miller v. Department of Corrections, 150 F.3d 1335, 11th Circle 1998, the 11th Circuit found that failure to address an employee's reasonable concerns about working conditions supported a finding of constructive discharge. Here, the agency's failure to accommodate or respond to appellant's requests demonstrates clear disregard for her working conditions. 2. The lower court erred in dismissing appellant's retaliation claim. Retaliation claims under Title VII of the Civil Rights Act require a showing that the plaintiff engaged in a protected activity, the employer took adverse action against the plaintiff, and there was a causal connection between the protected activity and the adverse action. Burlington Northern and Santa Fe Railway Company v. White, 548 U.S. 53, 2006. Protected activity. Appellant raised concerns regarding employers' actions that might relate to discrimination or retaliation and the significant impact of the demotion, separation from work, inability to quarantine, forced use of accrued leave, and remote work decision. These complaints constitute protected activity under federal and state laws. Furthermore, this case evidences retaliatory causal link with appellant's filed November 2019 EEO complaint where appellant was demoted and replaced by Manager Senior Advisor AS from this 2019 EEO case. Furthermore, 2019 EEO case TC and CK were also evidence to be relevant based on key witness Manager MJ of our 9 Oakland, California reports directly to Saipan DRM RC June 9, 2021, and reports to appellant May, September, and October 2021 during her time serving in Saipan alongside appellant. Adverse action. The separation from work November 8 to 12, 2021, forced use of leave, demotion, replacement of appellant with another person on December 12, 2021, replacement of appellant with another person on February 4, 2022, inability to quarantine for COVID-19, coerced use of LWOP and vacation time when previously approved for sick leave with COVID-19 symptoms, frequent lengthy meetings with EEO Counselor D and Manager Senior Advisor AS, separation of appellant from office work with restrictions April 2022, as well as others constitute adverse actions that significantly altered the terms of her employment. These actions forced appellant into a situation that undermined her ability to continue fulfilling the role effectively. Evidence also shows separately appellant's duties were severely changed November 2021 to July 2022, making it difficult for anyone to track what her duties were. Causal connection. The temporal proximity between appellant's complaints and the adverse actions suggests a retaliatory motive. In Kakmer v. SunGuard Datasys, Inc., 109 F.3d 173, 3d CIR 1997, the court held that close timing between protected activity and adverse employment action can support an inference of retaliation. Similarly, here, the close timing between appellant's complaints and her forced demotion, separation, inability to quarantine, and remote work with restrictions supports an inference of retaliation. Furthermore, direct evidence of Manager Senior Advisor AS from EEO 2019 case being deployed to serve with appellant to not just work with her, instead to specifically directly oversee and replace appellant within her hired position is further evidence of causal connection evidencing retaliatory intent of agency. Furthermore, direct evidence exists to support the need for agency and their witness statements' credibility to be sufficiently evaluated as no hearing has been provided nor have key witnesses of appellant been heard. Furthermore, direct evidence of causal link exists of 2019 EEO case CK completing hiring negotiations on or around June 9, 2021, to work in Saipan which leave agency with further motive to retaliate against appellant. Furthermore, direct evidence of causal link exists of 2019 EEO case TC seeking Manager MJ out to speak to her about appellant September to October 2021, just weeks before appellant's November 3rd evaluation, even though TC was in California and never serving Saipan, as MJ was located in Saipan. November 8th to 12th separation, November demotion, December replaced by manager and senior advisor EM, etc. that were reported early on within appellant's case. 3. Remote work policy and restrictions effectively altered the conditions of employment. The court failed to appreciate the material change in the conditions of appellant's employment caused by her transition to remote work with restrictions. In Farger v. City of Boca Raton, 524 U.S. 775, 1998, conditions that limit an employee's ability to perform essential job functions or interact with necessary office resources can create a hostile environment. The remote work arrangement isolated appellant from critical in-office interactions, making it impossible to perform essential job duties effectively. These actions created an environment where appellant had no reasonable alternative but to resign. Even worse, the cumulative adverse actions taken against appellant November to April preceding this April 18th adverse action already led to intolerable work conditions as evidenced within an emails from appellant to management that requests the agency address issues, informs of ongoing issues, and informs of her want to resign due to the intolerable conditions. Adverse actions chronologically clarified. Adverse action, negative evaluations placed to record i.e. November 3rd, 2021, January, or others without adequate justification or against agency policy secretly filed to records without appellant's review or signature. Normally, employees review and sign evaluations placed to record. Appellant was not provided this opportunity January to July 12, 2022 in retaliation for filing the EEO complaint. January meeting with Executive Director HMKL clarified KL quote, had nothing to justify the negative November evaluation. Instead, she placed it to record without anything to justify it. Regardless, it would stay placed to record and is not able to be withdrawn from being placed to record when appellant asked why it was placed to record. Appellant was never given evaluations for review following January 2022, although normally employees receive evaluations quarterly. Normally evaluations are given to appellant by Assistant Regional Advisor or Regional Advisor. Instead, Executive Official Director HMKL directly oversees appellant and signs her evaluations November 3, 2021 to July 12, 2022. Negative evaluations placed in appellant's employment record constitutes another adverse action under employment law. Negative evaluations can have significant consequences for an employee's future employment prospects, promotions, raises, and general reputation within the workplace. Courts have recognized that performance evaluations, when based on misleading, exaggerated, unjustified notions, or discriminatory assessments, can rise to the level of adverse employment actions. Relevant case law. Burlington Northern and Santa Fe Railway Company v. White, 548 U.S. 53, 2006, the court found that an employee's reassignment to a less desirable job, along with a negative performance evaluation, constituted retaliation. This case established that any action that would dissuade a reasonable worker from making or supporting a charge of discrimination can be considered an adverse employment action. Within appellant's case, there exist similar issues as well as multiple other additional adverse actions, all of which were dismissed within this appealed decision in error. Perry v. Harris Chernin Incorporated, 126 F.3d 1010, 7th Circle 1997. 7th Circuit considered whether negative evaluations could constitute retaliation when they are based on protected activity. The court found that negative evaluations that arise shortly after an employee engages in protected activity, such as filing a discrimination complaint, can be viewed as retaliatory and therefore constitute an adverse employment action. McCoy v. City of Shreveport, 492 F.3d 551, 5th Circle 2007, the court analyzed whether a performance evaluation was retaliatory. The Fifth Circuit ruled that a negative evaluation issued after the employee engaged in protected activity, like reporting harassment, was an adverse action because it affected the employee's promotional opportunities and created a hostile work environment. The decision completely disregards evaluations March 2021, April 2021 promotion to Manager Senior Advisor ICGS 12 pay position in Saipan, May 2021 evaluation, June 2021 evaluation, September 2021 evaluation, and October 2021 evaluations. All evidence appellant has no conduct issues and is instead a model employee, as TC stated January 9, 2020 within 2019 EEO complaint instead with exemplary evaluation marks above average to her peers within her new position's probationary period, evidencing she performs her duties well and is not even an average employee. As evidenced, conduct issues were a retaliatory pretext guise against wrongful adverse actions against appellant. This causation was evident as Manager Senior Advisor AS from appellant's 2019 EEO case was chosen to replace appellant within her position in which she was hired and oversee appellant as her direct supervisor until July 12, 2022 resignation that followed April 1, 2022 email to appellant supervisors and EEO Counselor Advisor D stating she wanted to quit her job because work conditions were so intolerable and specifically requested for harassment, discrimination, and retaliation to be halted. See April 2022 emails placed to record. 2. Adverse action. Separation from work, November 8th to 12th, 2021. The forced separation from work from November 8th to 12th, 2021 constituted an adverse action that significantly altered the terms of appellant's employment. During this period, appellant was prevented from performing her regular duties, which impacted her ability to fulfill her professional responsibilities. This forced absence, in effect, undermined appellant's role and contributed to a hostile working environment, leading to an eventual breakdown in her employment relationship. The court failed to recognize the material harm caused by this enforced separation. This forced separation also forced appellant to utilize earned sick leave, not be able to sleep at night, and work without pay when she was always able to work from the office. 3. Adverse action. Forced use of accrued leave time, November 8th to 12th, 2021 sick leave use, February 10th, 2022. Forced sick leave use, February 7th, 2022. Coerced to change previously approved sick leave to LWOP/vacation time although symptomatic for COVID-19, and previously approved sick leave for this time off. The forced use of appellant's accrued leave time further demonstrates the employer's intent to undermine appellant. By compelling appellant to take leave when she otherwise would not have, the employer manipulated the situation to interfere with her work schedule and deplete her earned leave. This action had the direct effect of limiting appellant's available leave for future personal, emergencies, or medical needs, further disrupting the terms of her employment, impact her well-being, and contribute to the overall adverse impact on her working conditions, which also contributes to a hostile work environment. Actions that limit an employee's flexibility, autonomy, or benefits can be considered adverse actions. Relevant case law. Chappell v. House. Author of the City of El Paso, 2005 U.S. App, Lexus 12463. Fifth Circle, 2005. The court recognized that an employer's decision to require an employee to take unpaid leave can constitute an adverse action. Harrison v. City of New York, 2018 U.S. DIST Lexus 112783. EDNY 2018, court ruling emphasized that forcing an employee to deplete their leave affects their autonomy and work-life balance, contributing to a hostile work environment. Cleveland v. Policy Management Systems Corporation, 526 U.S. 795, 1999. Supreme Court addressed the implications of denying an employee's claim for benefits after forcing them to take a leave of absence. The ruling highlighted that any action affecting an employee's ability to manage their leave and benefits can contribute to discrimination claims. Fowler v. State of California, 2018 U.S. App, Lexus 8533, Ninth Circle 2018. Ninth Circuit found that forced leave could be interpreted as retaliation for an employee's complaints about discrimination. The court held that compelling an employee to take leave when it was unnecessary constituted an adverse action because it limited the employee's control over their work situation and could deter others from making complaints. 4. Adverse action. Inability to quarantine for COVID-19. The inability to quarantine for COVID-19 constitutes an adverse action that significantly impacts an employee's health, safety, and employment status. During the pandemic, many employees faced the dilemma of needing to quarantine due to exposure or infection, including manager and senior advisor AS just 1 week after disallowing appellant to quarantine just a week before. Appellant sat in the adjacent desk and was not allowed to quarantine and pressured to work despite the risks. This scenario highlights the intersection of health concerns and employment rights. Employers have a legal obligation to provide a safe working environment. Forcing employees to work while they should be quarantining undermines that obligation, putting not only the employee at risk, but also their co-workers and the public. Courts have recognized that actions that endanger an employee's health can constitute adverse actions under employment law. This incident also evidences differential treatment among employees of different race and nationalities. Disruption of employment status. Denying an employee the ability to quarantine when necessary can lead to various negative consequences, including exposure to the virus, worsening health conditions, and potential long-term effects on their ability to work. Families First Coronavirus Response Act, FFCRA, supports employees in taking leave for COVID-19 related reasons without fear of retaliation. Families First Coronavirus Response Act, FFCRA. Section 510 of the FFCRA explicitly protects employees from retaliation if they seek to use their right to quarantine or take leave for COVID-related reasons. Employees can bring claims under the FFCRA if they are denied leave for COVID-19 related reasons or face negative employment consequences, including being forced to work despite being unwell or needing to quarantine. Adverse actions can include any employer behavior that negatively impacts an employee's employment status or working conditions, such as denial of leave for quarantine, forced continuation of work despite medical advice to quarantine, penalizing employees for exercising their right to quarantine or take health-related leave. Specifically, these three adverse impacts are evidenced against appellant when manager senior advisor denied appellant's request to work remotely and quarantine AS 1300 to 1600 Thursday, February 10, 2022. Manager Senior Advisor AS denied appellant's request to quarantine at around 1300 within February 10, 2022 meeting, which forced appellant to utilize sick leave to quarantine herself the following day, February 11, 2022. Manager Senior Advisor AS actions to penalize appellant February 7, 10, 11, 12, 13, 14, 15, and all subsequent dates for having COVID-19 symptoms and positive test results. Appellant was forced to work from offices 0800 to 1600 February 14, 2022, although against agency policy, as evidenced by February 13 email to Manager Senior Advisor AS. Manager Senior Advisor AS forced appellant to continue working from the office 0900 to 1300 February 15, 2022, despite medical advice from agency contact tracing team requiring appellant to immediately quarantine. Relevant case law. Caldwell v. United States, 2022 U.S. DIST Lexus 27169, Deeds, Kansas, 2022. The court held that an employer's refusal to allow an employee to quarantine when required due to exposure or infection could constitute an adverse action. The court found that by disallowing the employee to quarantine, the employer placed the employee at significant risk, thus adversely affecting the employee's health, safety, and impact their ability to safely perform their job duties. The inability to quarantine for COVID-19 exemplifies an adverse action as it directly affects an employee's health and safety and can result in detrimental employment outcomes. Employers' failure to recognize and accommodate quarantine needs during a public health crisis can lead to claims of retaliation or discrimination, further emphasizing the importance of maintaining a safe work environment. Ironically here, Caucasian white Manager Senior Advisor AS sat in the adjacent desk to appellant and was immediately quarantined for COVID-19 symptoms the following week due to her exposure to COVID-positive appellant because of her denial to quarantine appellant against agency policy clarified to her February 10 to February 13, 2022, within multiple emails. Most importantly, see the February 13th email sent around 1800 where appellant clarifies agency policy, requiring her to quarantine immediately. Manager Senior Advisor AS denied appellant's request to quarantine once again and forced her to work from the office the following day regardless of her COVID symptoms and not feeling well. This differential treatment abusively places employees at risk. Robinson v. Health and Hospital Corporation of Marion County, 2022 U.S. DIST Lexus 187522, SDIND 2022, the court ruled that a healthcare worker's inability to take leave due to COVID-19 exposure, which was necessary for their own health and safety, constituted an adverse employment action. The case involved a plaintiff who was denied the ability to take leave under the Family's First Coronavirus Response Act, FFCRA, after being exposed to the virus. This case underscores that denying an employee the ability to quarantine, especially when such leave is warranted under federal law, e.g., FFCRA, can result in harm to the employee's health and may be viewed as retaliation or discrimination. Refusal to provide leave or reasonable accommodation for COVID-19 exposure constituted an adverse action, as it placed employees at risk of further exposure, worsening health, and punitive measures due to their absence. Doyle v. University of California, San Francisco, 2022 U.S. DIST Lexus 59759, NDCal, 2022. Similar to appellant February 2022, this plaintiff was forced to work in person despite being advised by healthcare professionals to quarantine due to potential COVID-19 exposure. The court found refusal to allow the employee to quarantine and continue their work remotely was an adverse action that violated both health and safety regulations and the employee's rights under the ADA. Employers have a duty not only to protect the health and safety of employees, but also to respect medical advisories related to quarantine. Failing to do so can result in legal consequences, including claims of retaliation and discrimination. Smith v. City of New York, 2022 U.S. DIST Lexus 92040, SDNY 2022. Court held that employees who were denied the ability to quarantine or were forced to come into work despite exhibiting COVID-19 symptoms could sue for adverse action. The case examined claims of retaliation for employees who sought to take COVID-related leave or were penalized for following public health guidelines. Anderson v. Kellogg Company, 2021 U.S. DIST Lexus 137660, NDGA 2021. Plaintiff was denied the ability to quarantine after potential exposure to COVID-19, despite showing symptoms. The court ruled that this decision was an adverse action, as it not only endangered the employee's health, but also exposed others to potential harm. The court cited both OSHA regulations and FFCRA provisions as critical to the employee's right to quarantine. This case emphasizes that preventing an employee from quarantining or forcing them to work while symptomatic can be considered an adverse action under both federal and state employment laws, particularly where public health is at stake. Martinez v. City of San Diego, 2021 U.S. DIST Lexus 92263, SDCal, 2021. police officer who was denied paid leave for COVID-19 quarantine. The court found that the refusal to grant time off for quarantine due to exposure or infection was an adverse employment action. The officer was also subjected to workplace retaliation for following health protocols, which led to further legal action. Failure to allow quarantine or to treat COVID-19 related absences appropriately can constitute an adverse action, particularly in cases where it impacts an employee's health and safety or violates federal laws such as the FFCRA. The cited cases help demonstrate that employers' refusal to recognize the necessity of quarantine during the pandemic can lead to legal consequences, especially when employees are exposed to health risks or retaliated against for taking necessary precautions. 6. Adverse action. Failure to provide reasonable accommodation for COVID-19. Under the Americans with Disabilities Act, ADA, a disability is a physical or mental impairment that substantially limits one or more major life activities, such as sleeping, eating, thinking, and working. COVID-19 and its long-term symptoms, such as chronic fatigue, body aches, cough, and fever, can qualify as a disability under the ADA if these symptoms significantly impair an employee's ability to perform their job duties. In such cases, an employee is entitled to request reasonable accommodation to enable them to continue working despite their disability. Retaliatory actions due to appellant's physical disabilities included COVID symptoms and positive test results, where reasonable accommodation was requested but agency denied allowing modification to allow employee to complete their duties, such as allowing an employee to quarantine if they have COVID-19 symptoms or exposure, modifying work schedules to allow for rest or recovery, providing a modified work environment, such as telecommuting or adjusting physical workspaces to reduce exposure to others. In this scenario, an employee like appellant, who requested reasonable accommodations between Thursday at 1 p.m. and Tuesday at 1 p.m., February 10th to 15th, 2022, would be entitled to these accommodations if COVID-related symptoms or the need for quarantine are affecting her ability to perform essential job functions. By and through Manager Senior Advisor AS, agency's failure to provide requested reasonable accommodations Thursday 1300 to Tuesday 1300, as well as unlawful lack of remedy for pain and suffering for disability claim for depression, chronic stress, anxiety, repeated BV infections immune system, repeated chronic hives, COVID-19 body aches, cough, and fever with conclusive test results prove positive for COVID-19 and prove allergic reactions were not the cause of chronic hives would likely be considered an adverse action if the agency denied or ignored the requested accommodations, as this could be viewed as discrimination or retaliation for seeking accommodations for a disability. Relevant case law. EEOC v. Walmart, 2022 U.S. DIST Lexus 152846, ED Tennessee 2022. Court ruled in favor of the EEOC when an employee with COVID-related symptoms was not allowed reasonable accommodations, such as taking time off to quarantine. The employer's refusal to provide any modification to the employee's work schedule or environment was deemed an adverse action, as it negatively impacted the employee's health and ability to work. This case reinforces the idea that an employer's failure to accommodate an employee's request to quarantine or modify their work schedule due to COVID-19 symptoms can constitute adverse action under the ADA. Based on the case law precedent, the appellant was unlawfully denied reasonable accommodations, which constituted an adverse action against her on the basis of her disability. The decision to reject this as a valid basis for her claims was therefore erroneous. Denial of accommodations was a violation of the law, and that the decision by the administrative judge to dismiss claims based on the basis of disability was made in error. *****. 6. Adverse action. Demotion without formal written notice. Demotion without formal written notice constitutes an adverse action where an employee's job title, responsibilities, or salary is significantly reduced without proper documentation or communication from the employer. This lack of formal notice is against agency policy and can create confusion and insecurity for the employee regarding their status within the organization. Lack of due process. Employers are typically expected to provide formal documentation when making significant changes to an employee's role. Failing to do so can indicate a lack of transparency and fairness in the employment relationship. Courts have held that demotions lacking proper notice may be construed as retaliatory actions, particularly if they occur after an employee engages in protected activity, such as reporting discrimination or harassment. Relevant case law. Davis v. Town of Lake Park, 245 F.3d 1232, 11 Circle, 2001. The court held that an employee's demotion without formal written notice or a clear explanation could support claims of retaliation, as it created a significant change in the terms of employment. If a demotion occurs in a context where the employee has previously raised concerns about discriminatory practices or treatment, it may further substantiate claims of discrimination or retaliation. Courts may scrutinize the lack of formal documentation as indicative of a potentially unlawful motive behind the employer's actions. Burlington Industries Incorporated v. Ellerth, 524 U.S. 742, 1998. This case established that adverse employment actions like demotion, do not need to be formally written to qualify as actionable under Title VII of the Civil Rights Act of 1964. The Supreme Court emphasized that an adverse action can include tangible employment actions like demotion, reassignment, or a pay cut. Adverse action does not require formal written notice to be legally significant if it materially affects employment conditions. Ray v. Henderson, 217 F.3d 1234, 9th Circle 2000. Ninth Circuit ruled that adverse employment actions include not just tangible demotions or pay cuts, but any action that materially affects the terms and conditions of employment. Demotion without formal written notice can qualify as an adverse action if it has an impact on an employee's work environment or responsibilities. The court clarified that adverse actions do not necessarily have to be significant or substantial to be a protected activity. Sutters v. Easton Area SCH, DIST, 325 F.3d 432, 3D CIR, 2003, Third Circuit held that a constructive demotion, which includes a significant reduction in job duties or status, without formal notice, can constitute an adverse employment action. Alvarado v. Texas Rangers, 492 F.3d 605, Fifth Circle 2007, demotion without formal notice can lead to a claim of disparate treatment under Title VII, provided the plaintiff shows that the adverse action was based on unlawful discrimination or retaliation. Burlington Northern and Santa Fe Railway Company v. White, 548 U.S. 53, 2006, Supreme Court case, clarified the scope of adverse action in the context of retaliation claims under Title VII, where the court held that an adverse action is any action that would dissuade a reasonable worker from engaging in protected activity, even if the action is not as severe as a tangible employment action, e.g., firing, demotion, discriminatory suspensions. Tangible changes to work responsibilities or conditions are not required. See work logs and emails placed to record. With respect to the decision here appealed by the appellant, the court erred in that an adverse action refers to any action taken by an employer that might deter a reasonable employee from engaging in protected activities and do not have to be severe, such as termination or demotion, to qualify as adverse. An employer might change an employee's schedule, assign less favorable duties, or publicly criticize the employee. While these actions may not appear significant or severe on their own, they could still qualify as adverse actions if they would dissuade a reasonable worker from engaging in protected activity. Courts have recognized that even subtle changes in work conditions or treatment, if retaliatory in nature, can be sufficient to constitute adverse action. The key is whether the action, taken in context, could discourage someone from asserting their legal rights, not whether the action involved major changes to their job or pay. The administrative judge erred in their determination that issues must be significant or severe to have an adverse impact on the employee. Instead, any action that might deter a reasonable employee from engaging in protected activities and do not have to be severe qualify as adverse. In appellant's case, the agency requests of sanctions against appellant within the pre-hearing motions also constitutes a retaliatory adverse action taken that might deter a reasonable employee from engaging in protected activities, and this by itself evidences ongoing retaliatory actions against the employee, which the administrative judge erred in not providing appellant any remedy for when it was decided all claims would be dismissed, and no hearing would even be provided to the appellant. Chronologically important facts. April 1st, 2022, appellant notified agency management of the intolerable work conditions, which included public criticisms by Manager Senior Advisor AS, where in an email appellant requested concerns be addressed and unlawful activities be halted. See emails. Appellant took sick leave at 11:30 a.m. due to the intolerable work conditions and informed management the ongoing failure by the agency to address issues was causing appellant to feel the need to resign within her position. See emails. Slow this video speed if you wish to take notes as you follow along. 7. Adverse action. Soft termination, November 3rd, 2021 to July 11th, 2022. Soft termination refers to indirect actions taken by an employer that effectively end an employee's position without formally declaring a termination. This can manifest through various methods, such as reducing responsibilities, isolating the employee, or creating a hostile work environment that pressures the employee to resign. Employers may engage in soft termination by reassigning an employee to a position with diminished responsibilities, changes in duties, creating a hostile work environment, impacts to employment benefits, impacts to promotions or capacity to secure future jobs, issuing consistent negative evaluations, affecting an employee's reputation in their field, impact overall job satisfaction, or by imposing unrealistic performance expectations. These actions can undermine the employee's professional standing or motivation, leading to a sense of being marginalized within the workplace. Courts have recognized that adverse actions include behaviors that manipulate an employee's working conditions to force them out of their job. All of this is relevant to appellant's EEO case. Relevant case law. Harrison v. City of New York, 2018 U.S. DIST Lexus 112783, EDNY 2018, Court held that forcing an employee to work in a hostile environment, coupled with diminished job responsibilities, could be deemed an adverse action that supports claims of constructive discharge. Lopez v. S.B. Thomas Incorporated, 831 F.2d 1184, 2d CIR 1987. Court in this case held that a constructive discharge claim is valid when the employer creates conditions so difficult that a reasonable employee would feel compelled to resign. The court highlighted that merely demoting or reassigning an employee in bad faith can support a claim of constructive discharge. Soft termination can include adverse actions like demotion, drastic reduction in responsibilities, or any action taken by an employer to push an employee out. Spencer v. Walmart Stores Incorporated, 469 F.3d 311, 3d CIR 2006. Third Circuit reaffirmed that a constructive discharge can occur when an employer's actions make working conditions intolerable. The employee claimed that continuous harassment and reduced duties forced her to resign. Soft termination can occur when employers reduce job responsibilities or engage in ongoing harassment, creating an untenable work environment. Ames v. Iowa Depth of Transportation, 928 N. W.2 D 295, Iowa 2019, Iowa Supreme Court examined a constructive discharge claim where an employee resigned after being given undesirable assignments and facing a hostile work environment. The court ruled that if an employee resigns because of intolerable conditions imposed by the employer, it constitutes constructive discharge. Unfavorable work assignments or a toxic workplace can lead to a claim of constructive discharge, which is often used to describe soft termination. McWilliams v. Western Pennsylvania Hosp, 717 F.3d 153, 3d CIR 2013. The court found that an employer's actions, including a demotion and withdrawal of critical job duties, constituted constructive discharge. The employee resigned because their new role was significantly inferior to their previous one. A soft termination can occur when the employee's new role is drastically inferior to their previous one, effectively pushing them to resign. Young v. Southwestern Savings and Loan Association, 509 F.2d 140, 5th Circle 1975, court held that constructive discharge exists when an employer creates a work environment so unpleasant that a reasonable person would resign. In this case, the employee alleged that actions taken to reduce their job duties and isolate them from meaningful work led to their resignation. Job isolation or significant reduction in duties can qualify as a form of soft termination or constructive discharge. Goss v. Exxon Offices Company, 747 F.2d 885, 3d CIR 1984. Court ruled that a constructive discharge occurred when the employer intentionally changed the employee's job responsibilities and work environment to make the position unbearable, forcing the employee to resign. Deliberate actions by the employer to make the employee's work environment intolerable, even without formal dismissal, can amount to soft termination. 8, 9, and 10. 3 separate adverse actions. Replacement of appellant within the position in which she was hired with Caucasian white individuals specifically, December 12, 2021 by Manager Senior Advisor EM, February 4, 2022 by Manager Senior Advisor AS, June 2022 by Unqualified Trainee JV. December 12, 2021, February 4, 2022, and June 2022 appellant was effectively replaced in her position when Manager Senior Advisor EM, then Manager Senior Advisor AS, then JV was assigned to replace appellant within her position and complete her managerial duties. This act constituted a demotion, as it deprived appellant of the responsibilities, authority, and respect that her position entailed. This replacement diminished her role within the organization, signaling a material change in her employment status without any legitimate justification, further constituting an adverse action. The court failed to adequately consider this significant alteration in the conditions of appellant's employment. This second replacement confirmed the employer's continued intent to marginalize appellant, creating an untenable situation where she was effectively sidelined from her role. This action not only demoted her but also sent a clear message that her position within the company was no longer secure or respected. The ongoing replacement, combined with other adverse actions, cumulatively forced appellant to resign, and the court failed to recognize this forced resignation as a constructive discharge. All began with JV incident NOV 7, 2021, where JV made verbally abusive publicized statements about not respecting appellant's managerial position before leaving the offices to go home without approved leave authorization. Furthermore, based on replacement actions being in violation of company policies, one can use this material change in appellant's employment status to show pretext in a discrimination case. Relevant case law for all replacement adverse actions. Nasser v. University of Texas Southwestern Medical Center, 570 U.S. 338, 2013. This case dealt with retaliation claims and held that a plaintiff must prove that the adverse action, e.g., replacement, would not have occurred but for the employer's retaliatory intent. Piverato versus Innovative Systems Incorporated, 191 F.3D 344, 3D CJR 1999. Third Circuit found that an employer's failure to follow its own policies for promotion and replacement can be evidence of discrimination. An employee replaced by someone else in violation of company policies can use this to show pretext in a discrimination case. If the replacement process violates company policies or standard procedures, it may strengthen the employee's claim of discrimination. Diaz versus Kraft Foods Global Incorporated, 653 F.3D 582, 7 Circle 2011. Court held that replacing an employee with a less qualified individual of a different gender or race can support a claim of discrimination. The plaintiff was able to show that their replacement was less qualified, strengthening their case that discrimination was at play. An employee replaced by someone less qualified or who is a member of a different protected class may use this as evidence of discriminatory motive. Appellant was forced to train and complete compliance projects for Manager Senior Advisor AS and JV because they both never completed IA, PA, or HMGP program compliance reviews for Saipan projects or trained to oversee Saipan Environmental Department, unlike Appellant and Replacement EM. JV was a trainee unqualified specialist based on her Saipan deployment orders placed to record, as well as a new agency employee hired on or around September 15, 2021. When Manager Senior Advisor AS temporarily left, she promoted unqualified trainee JV to her position for the time she was away, although Appellant was both qualified, hired, and trained for this specific position. Replacement is motivated by discriminatory factors, race, gender, age, etc. As both individuals are Caucasian white, Appellant was qualified for the role. The replacement is less qualified. Replacement occurs after the employee has engaged in protected activity and violates company policy or standard procedures. JV was not just less qualified, instead not qualified and deployed as a trainee, which ranks below of a qualified specialist, which ranks below a manager, which ranks below an EHAD senior advisor position based on environmental PTB qualification system. Appellant was a local hire of Saipan qualified specialist hired specifically for the senior advisor position. See job description and JV deployment orders placed to record. See organization qualifications flow chart placed to record. An unqualified specialist ranks below qualified specialists. Qualified specialists rank below managers. Managers rank below advisors. A lead position is below the rank of manager. Appellant was demoted from hired senior advisor position to almost as low as it gets, a qualified specialist position, while unqualified trainee JV was promoted up to lead, manager, and lead senior advisor, although never a qualified specialist in accordance with organization ranking systems standard operating procedures placed to record. See figure placed to record. Lead advisor is Tier 2. Manager is Tier 3. Lead is below Tier 3 and above Tier 4. Qualified specialist is Tier 4. Unqualified specialist, trainee, is Tier 5. 11. Cumulative adverse actions and impact on terms of employment. Relevant case law. Young versus Southwestern Savings and Loan Association, 509 F.2D 140, 5th Circle 1975. Court held that constructive discharge exists when an employer creates a work environment so unpleasant that a reasonable person would resign. In this case, the employee alleged that actions taken to reduce their job duties and isolate them from meaningful work led to their resignation. Job isolation or significant reduction in duties can qualify as a form of soft termination or constructive discharge. The facts unequivocally demonstrate that the appellant was not merely subjected to isolated reductions in duties justifying constructive discharge, but was also the target of a coordinated pattern of retaliatory adverse actions. These actions, taken collectively, created a hostile work environment and directly led to the appellant's resignation. The cumulative effect of these adverse actions, designed to undermine the appellant's role and professional standing, was completely ignored, goes beyond mere reductions in responsibilities, and instead constitute a concerted effort to force the appellant out, clearly supporting a claim of constructive discharge. As a U.S. Coast Guard veteran, appellant is resilient and has never quit a job in her life except once for a promotion to a better position with ACWD. Here, appellant only resigned due to the severe retaliatory adverse actions taken against her. Many of these actions are not arguable or circumstantial, instead direct evidence of sick leave, performance evaluations, emails, work logs, oversight from the most senior executive officials in all of agency, i.e. agency EEO advisor, HM director, OPR director, and hiring offer letter and job description, and causal link of manager senior advisor AS from 2019 EEO case, specifically replacing appellant in her hired position although not trained or capable of performing the lead senior advisor. Duties. Appellant was demoted and forced to do their duties and train them because they were not able to perform the duties and ensure compliance for their department, which was their job as senior advisor of the environmental department. Here the EEOC administrative judge errs when it determines it is both reasonable to dismiss all retaliatory adverse actions taken against appellant and never provide appellant or appellant's key witnesses the opportunity to be heard within a hearing. Never were key witnesses of appellant listed within her pre-hearing report heard, and this by itself makes it unlawful for appellant to not be provided a hearing. Appellant and key witnesses are not heard within any hearing, and cumulative retaliatory adverse actions are directly evidenced but never remedied within appellant's case. Thus, the EEOC process is clearly broken. Maybe it is more likely than not. Social justice is the only means for any resolution and the only viable manner to gain justice against all powerful agencies that cause undue harm against employees based on a broken EEO process evidenced pervasively here. On top of all this, the EEOC administrative judge herself observed the agency take continued adverse actions against appellant when the agency requested sanctions against the appellant within the pre-hearing motions, although this action might deter an employee in filing a complaint, although a protected activity. This in itself is first-hand direct observation of a retaliatory action within the EEO process that the administrative judge both observed firsthand and ignored, with no remedy offered to appellant, instead a full dismissal of all claims. Slow this video speed if you wish to take notes as you follow along. Even worse, the agency still more likely than not retaliates through present, as appellant presently served as an agency contractor that has never been deployed March 2023 through present, although the best candidate on her supervisor's roster and always available to deploy with completed ID credentials and background checks, all while Hurricane Helen and Milton reap havoc all up and down the coastline where appellant would work. This lack of deployment orders due to retaliation still experienced today has led to pervasive financial suffering and loss of income, even though a highly qualified top candidate to serve the nation within these or any other disaster. As an alumni of Vermont Law School and member of the Omicron Delta Kappa Leadership Society, like many of our honorable past presidents, appellant truly does not believe in the EEO process. You may understand why after watching these videos of our life story. Instead, appellant feels the EEO process is a waste of life where you relive trauma to gain fair decisions when nobody cares, and fairness is impossible because claims are always dismissed partially or fully, decisions are delayed and untimely, and entities intentionally never address issues not just as you complain but also within the EEO process itself. Entities do everything they can to defame, slander, and libel you instead of resolving issues at the lowest levels. The entities should in a fair system be on your side against the offender, not the victim employee. Thus, the EEO process is broken. Entities should have positive intentions of resolving issues, not fighting them and silencing complainers. No one wants to complain or experience retaliation. The EEO process enhances hostile work environments and retaliation. If you complain in any way, you should expect both a hostile work environment and retaliation. The worst of them, a loss of your job or income that you rely on, will almost always come to pass in my eyes, whether it is weeks or years into the future. For appellant's case, in her 2019 EEO complaint, the manager specifically stated January 9, 2020, that it took 3 years to get rid of the last employee who complained. Here, the agency intentionally spent 3 years getting rid of appellant in just under 3 years and gains no justice because the EEOC administrative judge ignored all unlawful actions against appellant and dismissed all claims within their decision placed to record. EEOC process is a more likely than not a completely and totally broken system waste of life, where justice is more likely than never to be afforded to the employee who complains. Your complaint will more likely than not be not an actual protected activity because it's not protected in actuality. EEO administrative judges do close an eye to unlawful actions. Good luck getting justice in a broken process. Comment the word broken to show you watched this video and support us in making more videos for you. Comment below the word justice if you agree it is important to tell your story to foster more honorable outcomes within EEOC processes. No justice is possible against the all-powerful agency, even as agency's reputation is in shambles as many employees risk their lives today to serve disaster victims. Shootings and militia attempt to murder agency employees and make employment serving the agency not the most desired or safe because the agency reputation is not good based on the opinion of public at large or in general. Specifically, my supervisor's brother was experienced an in-work office shooting and went into critical care at the hospital due to a shooting at his office in 2023, and incidents exist Florida to North Carolina today based on public reports. Appellant chooses to serve agency because her resume is literally perfect for agency and she can best serve humanity in disasters based on her master's in environmental law from Vermont Law School, U.S. Coast Guard and U.S. Coast Guard Academy experience, NOAA, EPA contractor, past agency experience, and other professional work experience. This is not an exaggeration and said with much integrity, like everything else appellant says in accordance with U.S. Coast Guard core values of honor, respect, and devotion to duty. Appellant's resume and evaluations speak only of excellence and selflessness. Negative performance evaluations are subjective, unjustified, or falsified with exaggeration. Appellant is today a qualified GS/IC 13 level due to her qualifications and 1.5 years of service in the lower rank in a GS/IC 12 position with this agency. Regardless, appellant is not deployable and never deploys or works since March 2023, although always available and financially suffering. Appellant respectfully urges the EEOC to take decisive action to prevent agency from misusing taxpayer dollars to conceal EEO violations through retaliatory practices. The agency never took any actions to address appellant's complaints November 2019 to February 2021 for the 2019 EEO case. The agency never took any actions to address appellant's complaints November 2021 to present within this retaliation EEO case. Appellant appeals today. The agency must be held accountable for never addressing EEO complaints. The agency must be held accountable for never addressing EEO complaints at the earliest stages, utilizing mediation and both informal and formal processes to ensure a positive, safe work environment for all employees as mandated by law. Instead, the agency harassed appellant and used mediation meetings to fabricate evidence to get rid of appellant and impact appellant's ability to do her job. How abusive can an employer be and completely and totally get away with it? The case facts here are honestly insane, and the decision to dismiss all claims by the EEO administrative just is equally insane. Well, maybe the appellant is the insane one to think justice was even possible within this EEO process. That was probably true insanity. This process is such a traumatic waste of life as justice never occurs for the employee. You will always be taken advantage of. Expect to be harassed for filing a complaint. Expect to be retaliated against for filing a complaint. Expect to lose your job or income for filing a complaint. Expect for your reputation to be degraded for filing a complaint. Expect other employees to avoid you or avoid be a witness because they do not want to experience retaliation for being a witness. It is more likely than not, justice will not be given. Some or all claims will be dismissed because entities are experts at getting claims dismissed and have entire teams dedicated to this specific task. Justice will be delayed because entities are experts at getting claims dismissed and have entire teams dedicated to this specific task. Your reputation will be impacted because entities are experts at getting claims dismissed and have entire teams dedicated to this specific task. As we all know, the best way to get cases dropped is to degrade the credibility of the complainer. Your reputation is already not good. Nobody likes a complainer. The EEOC here forgets. Nobody likes complaining. This protected activity is not protected. Employees are abused throughout the EEO process. The EEO process is a traumatic waste of life. It is never something an employee wants to experience. Even if you win your case, it is still not worth suffering through the process. The entity will probably repeatedly do the same actions to other employees regardless of you winning your case. This is because they know most cases based on statistics will always be in their favor with partial or full dismissal of claims. You start the EEO process as a complainer. The entity starts the process as an employer of a supervisor who is promoted to this high rank because they must be great, right? You start your case crawling yourself out of a hole, disadvantaged and abused, with an entire strong, powerful entity against you gaining justice. Good luck getting justice. Justice on all claims is impossible if you ask me. The agency will successfully get certain claims dismissed because they are good at what they do, have an entire team of licensed professionals hired for this purpose, and start the EEO process being perceived with a great reputation as they are not the complainer. Appellant seeks a fair resolution of her claims, including constructive discharge, retaliation, harassment, hostile work environment, differential treatment, in comparison to JV and Manager Senior Advisor AS, and discrimination based on her race, national origin, and COVID-19 disability. Appellant requests the court acknowledge refusal to allow key witnesses to testify and the failure to provide a fair hearing undermine the integrity of the EEO process and her right to a just outcome. Appellant requests the EEOC take actions to ensure the agency provides employees positive, safe work environments as required by law. Appellant requests immediate reinstatement to her GS/IC 12 Environmental Senior Advisory position with her earned Step 2 pay increase in Saipan, in accordance with the April 2021 job description already placed to record. This reinstatement must occur once the necessary corrective actions are taken to establish a positive and safe work environment in Saipan, Northern Mariana Islands, as required by law. The appellant's reinstatement should reflect the full scope of her previous role and responsibilities, ensuring she can return to a workplace free from retaliation, discrimination, and harassment. With 3 years serving agency and a master's in environmental law from Vermont Law School, appellant, although hired to only complete IA program work in Saipan, began completing PA program work by June 2021 and HMGP program work by August 2021, which evidences appellant's reputation of excellence and exceeding her job duties to achieve more than just the duties in which she was hired. Appellant went above and beyond to become a compliance expert for the Archaeological Treatment Plan and Biological Agreement compliance on Saipan Island. Appellant was not just competent, but excelled within the 6-month probationary period of serving as Environmental Department Senior Advisor for Individual Assistance, Public Assistance, and Hazard Mitigation Grant Programs, and this was directly evidenced by every single evaluation placed to record March 2021 pre-promotion to October 31st, 2021, post-April 9th, 2021, promotion start of work date. This 6-month of excellence in 5 or more performance evaluations is direct evidence that cannot be overlooked. Instead, it makes it clear retaliation blatantly occurred. If not reinstated to this position, appellant requests agency-approved deployment orders for her to deploy within her current agency contractor position because although the best applicant on the roster, she has never deployed not even for 1 hour of pay although credentialed since March 2023 with the identification card, completed background checks, and standing by to deploy within countless presidentially declared disaster declarations to include the complete destruction of property and loss of lives within Hurricane Helen and Milton in Florida, as well as tornadoes and severe storm surge flooding caused by the severe storms. Other disasters could also deploy her, but none do. No agency environmental employee has a master's from Vermont Law School and bachelor's degree in marine environmental science with minors in meteorology, oceanography, and nearly marine biology, with over 165 agency relevant certifications and managerial service in all agency environmental programs IA, PA, and HMGP. Instead, most of appellant's coworkers have no master's degree or only have experience working in one program, not all 3 of IA, PA, and HMGP. We all would not be here today within this EEO process if the agency addressed appellant's reported concerns at the lowest levels within the December 2021 mediation process. Appellant's life was wasted reliving trauma for justice. No justice today. The administrative judges and EEOC staff's life was wasted reviewing all claims and evidence. Tax dollars are exorbitantly wasted to get us here to this dismissal of all claims. Agency staff and executive senior staff excessive labor hours and travel expenses exist to get us here. We're all preventable. The problem is, the agency never wanted to resolve appellant's concerns within December 2021 informal EEO mediation processes. Agency intentionally demoted appellant and took adverse actions against her. When Region 9 agency executives learned of appellant's 2019 EEO complaint through CK and TC, who were also deployed to serve our 9 Director of Hazard Mitigation KL and REO Regional Advisor MA, as well as separately through MJ report to DRM RC and retired REO Regional Advisor, serving before Regional Advisor MA. Agency intentionally had JV instigate issues with appellant to get her demoted, as evidenced by the call appellant overheard between JV and Regional Advisor MA behind closed F4 logistics. Office door. See evidence placed to record for the entire account of events. December 2021. All appellant asked for was the reinstatement of the position in which she was hired, her old desk and office back, resolution of Executive KL's contradictory unjustified performance evaluation, and a resolution between JV, agency management, and appellant. Appellant should also have forced use of leave returned to her, including but not limited to November 8th to 12th, 2021, February 11th, 2022, April 1st, 2022, and on subsequent days. All the agency needed to do was say yes to implementing straightforward, simple requests, as by law appellant should have been secure in her position, not able to be demoted, not forced to take leave, and separate from work offices in November, because the actions were against agency policy to implement these actions. It was only agency policy for appellant to quarantine for COVID-19, but appellant was denied this as white Caucasian employee senior advisor was quarantined for her exposure to appellant the following week. Direct evidence of differential treatment and agency actions taken against agency policy to not quarantine appellant. Appellant only reported concerns about JV's health and safety when she did not check in or arrive to work the following day, which is agency policy for her to do as manager senior advisor to JV. Agency actions against appellant directly violated agency's own policies and evidenced the retaliation as the actions were unjustifiable, as appellant just received an excellent performance evaluation just days prior and only implemented agency policy to ensure health and safety of the staff she was hired to oversee in her senior advisor position. Agency's failure to comply with basic legal obligations exacerbated the harm to appellant and reflected a disregard for her rights under the agency's policies. Appellant completed mediation on or around December 15th, 2021. Instead, agency EEO counselor notified appellant in an email that agency management was taking no actions to resolve appellant's reported concerns. This EEO counselor was then replaced by the most senior EEO counselor advisor in all of the agency, who was hired as the agency was established long ago. Separately, several executive officials began to directly oversee appellant and her EEO complaint on November 3, 2021, just months after being informed of appellant's 2019 EEO case. Manager Senior Advisor AS from appellant's EEO 2019 case would replace appellant in her position and directly oversee her February 4, 2022, through her resignation just under 5 months later. Within 1 week, appellant's sick leave and ability to safely quarantine was impacted. Manager Senior Advisor AS the following week quarantined after her exposure to appellant because she denied appellant's quarantine requests and sat adjacent to appellant. Within 4 weeks, appellants had conduct issues fabricated against her to impact her ability to pursue the fitness program schedule. This denial by Director KL and Manager and Senior Advisor AS led to appellant being unable to adjust her work schedule for the program, although already approved by her previous Supervisor Regional Advisor and/or DRM-RC. Appellant was subjected to repeated, prolonged, and frequent meetings with Manager Senior Advisor AS and EEO Counselor Advisor D, which served as a tool of harassment and intimidation. These meetings were not conducted in good faith, but were instead designed to undermine appellant's EEO complaint and manufacture pretextual reasons to justify the OPR complaint that followed just weeks later, which separated appellant from work and placed restrictions upon her, as well as eventually form reason to terminate appellant if she did not resign. The causal link is blatant, regardless, dismissed by the EEOC administrative judge in error. This pattern of conduct reflects a clear attempt to retaliate against the appellant and obstruct her pursuit of legitimate claims under EEO protections. Within these 6 weeks, appellant was separated from work, forced to not complete required trainings, work in a restricted status, and work remotely from home with no ability to come to offices or gain free COVID testing kits all agency staff and all Saipan residents had free access to. In the next few months, trainee JV was promoted to Manager Senior Advisor AS's position temporarily when Manager Senior Advisor AS was away. Appellant was disallowed to participate in meetings, i.e. IAPHC meetings, DRM meetings, HMGP meetings, TAC contractor meetings, and others within repeated multiple emails placed to record. Appellant was forced to start completing daily work logs. Appellant had her projects redirected to California staff, i.e. Allison Miller and others, who were not on Saipan Island. Appellant was repeatedly told in emails from Manager Senior Advisor AS and Director KL that she was to not email or interact with co-workers, specifically employee SM, KK, IA staff, Logistics Chief EJ, DRM RC, and others. See emails placed to record. Appellant was disallowed to visit the offices, attend meetings she normally attended, participate in events outside of work hours, do required mandatory trainings, manage her work calendar for non-work hours, take previously approved sick leave, communicate or email others, maintain her original office and desk at F4, quarantine for COVID-19, participate in fitness program schedule, maintain the position and duties in which she was hired for, view and sign off on 2022 performance evaluations, along with other retaliatory actions that impacted her job. The prolonged frequent meetings with EEO Counselor Advisor D and Manager Senior Advisor, as were over 2 hours long several times per week, were retaliatory and led to this military veteran ending meetings in tears, hyperventilating, which impacted her job. Normally, you do not see military veterans, professional advanced open ocean scuba divers, or Southern Ocean Antarctica professional rescue swimmers cry for trivial, insignificant issues, complain for lawful actions, file EEO complaints that have no standing, or quit a job, especially when they enjoy overseeing compliance projects, have perfect credentials for the employment opportunity, and have extensive experience to excel both as a leader and employee for any entity. Employee today serves the agency as a never deployed agency contractor since March 2023. This is more likely than not blatant ongoing retaliation that the appellant will never gain a remedy for. All of the actions, forced remote work, restrictions placed on her, separation from duties, negative evaluations, use of accrued leave, demotion, repeated replacement within her hired position, inability to quarantine, and other adverse actions, collectively amounted to adverse actions that significantly altered the terms of appellant's employment. These actions created an environment that left appellant with no reasonable alternative but to resign, making the employer's conduct tantamount to a constructive discharge. The court failed to consider the retaliatory cumulative effect of these adverse actions and their substantial impact on appellant's ability to perform her job, which ultimately forced her out of her position. Conclusion. The issues clarified here within this appeal were dismissed within the appealed decision and should be reviewed for error. The appellant has suffered tremendously economically, physically, medically, and emotionally. Punitive damages should be placed against the agency based on the facts of the case. Otherwise, expect agency to continue unlawful actions against employees. Agency has a history of retaliatory, unlawful actions against employees. For the EEOC to not seek a hearing or provide appellant a resolution when a pattern of retaliation exists is not only a failure to uphold the principles of justice, but also blatant, as conduct issues were alleged for missed meeting or check-in while Caucasian white JV was never disciplined for leaving work, never checking in by 8 a.m., and never going to work the following day without authorization November 7, 2021, well before any conduct issue was created against appellant. Similarly, appellant placed to record evidence of Caucasian white employee AM, Manager Senior Advisor AS, and JV arriving late to work on a regular basis multiple times. Appellant evidenced the entire R9 environmental team, who are all Caucasian white, based on my observations and memory, missing check-ins regularly, and unlike appellant, they worked from home indefinitely April 12, 2021 to March 2022 due to COVID-19, while appellant worked from the offices daily and was disallowed to quarantine not for prevention. Instead, with actual COVID symptoms and exposures reported to management February 10th and JV Tuesday, February 8th, just 2 days prior. Differential treatment does not have as high a standard of proof, and here case facts evidence unequal discipline for similar infractions. Appellant is determined to have alleged conduct issues for trivial matters or infractions others gain no discipline for. Subjective decision-making processes disadvantage a particular group of individuals who are not Caucasian white. A pattern of promoting employees outside the complainant's protected class. Caucasian white employees are promoted against agency policy. Caucasian white employees are quarantined in accordance with agency policy for their exposure to appellant causally linked the week after appellant was denied reasonable accommodation request to quarantine for COVID-19. Disparate enforcement of workplace policies exists. Smash the like button for the YouTube algorithm. For the foregoing reasons, appellant respectfully requests this court reverse the decision of the lower court, finding that the agency engaged in retaliatory conduct and created working conditions that amounted to constructive discharge. Constructive discharge, retaliation, harassment, hostile work environment, differential treatment, and discrimination against appellant on the basis of race, white Middle Eastern, national origin Iranian American, disability and reprisal, prior EEO activity. November 2019 EEO case are demonstrated and evidenced with great detail both circumstantially and directly, as well as reverse the decision to deny appellant her right for her and her key witnesses to be heard within an EEO hearing. For justice to occur, appellant's key witnesses must be heard or fair hearing be provided. The case should be remanded for further proceedings consistent with these and other above findings. The agency should receive sanctions for taking actions against the appellant to delay justice, retaliate against appellant for protected activities, and unlawful destruction and manipulation of evidence for this case. See pre-hearing report motions submitted to evidence September to October 2023. Smash the like button for the YouTube algorithm. As stated in appellant's pre-hearing reports and here in this appeal, circumstantial and direct evidence for all claims were placed to record in much great detail, making a final decision in appellant's favor reasonable, consistent with case law, as well as in accordance with the preponderance of evidence standard and standard of review requirements. Appellant again requests an amicable just resolution of claims and sanctions be placed on the agency. I apologize for being detailed. I simply always do more in higher quality, in less time than others due to my work ethic, passion, and intelligence. It is who I am. I am incapable of not doing my best in something, especially when ethics require it. Appellant. Be the change you wish to see in the world. Mahatma Gandhi. This appeal was drafted entirely by appellant with no review or advice by any other individual. Sorry, I am not a licensed attorney. Appellant. Thank you for your time and consideration. Respectfully submitted with only positive, honorable intentions. I, appellant, hereby affirm that all the statements made in this appeal are true and correct to the best of my knowledge. I understand that any false information or misrepresentation may result in the dismissal of claims. I, appellant, certify a copy of this brief was uploaded to EEOC's public portal at publicportal.eoc.gov, as well as emailed to agency attorneys on file, agency equal rights offices, and the Honorable Administrative Judge EEOC Philadelphia District Office. Smash the like button for the YouTube algorithm. Subscribe by clicking on my on-screen photo. Comment below, what do you think of this appeal we filed today? Comment below, do you have questions about the EEO process or appeal process? Have you ever experienced any of these issues at work? Did you receive a different outcome for your case? Why do you think the administrative judge dismissed this case for appellant, and why did your case get a different or similar outcome in your opinion? Feel free to share your story below. Let's have an honest discussion about all this. Disclaimer. This video is based on the personal experience and opinions of one individual based on positive, honorable intentions to simply tell a story, analyze legalities of situations, and provide case law so the audience can be more knowledgeable about EEO processes or determine whether the EEO process is a process that can help them. We are not legal attorneys, and this video is not intended to provide legal advice. We recommend never taking actions based on information found online. Instead, seek help from a licensed attorney who knows your situation. Our personal experiences are based on truthful narrative and integrity-based opinions of one employee with a focus on positive intentions, accuracy, and truths. EEOC case decisions may be complicated and affected by a judge's personal opinions or understandings of the law or case law precedent. We do not wish to affect or harm anyone's reputation. Instead, clarify our story. analysis of law, and analysis of case law so you can understand why we won. Feel the EEO process is broken and a waste of life too. Recommend you quit jobs that are unsafe or unlawful. 3. Expect retaliation in response to filing any complaint or reporting any concern. 4. Expect witnesses to be retaliated against if they chose to support or be a witness to anything. Smash the like button for the YouTube algorithm. Remember, you can always slow this video speed if you wish to take notes as you follow along, or rewatch this video, or check out our playlist of videos on our YouTube channel because we have our videos organized by topic into playlists for easier viewing opportunities. Crush that like button to supercharge the YouTube algorithm and boost my channel to help support me making more great content for you. Subscribe by clicking my on-screen photos and playlists. Let's enhance your chances for success in life together. Like, share, and comment to support the channel so I can keep bringing you more content. Thanks for joining. See you in the next one. Thank you for clicking the on-screen images to subscribe and watch more videos.